I love a buttered biscuit.
Stop! Okay, sorry.
Wow, weird stuff happening with the computers. I don't know what just happened. I was like, crazy. Having trouble streaming to weird stuff. Hey, Christine, how you doing, Puddletown? You're the only one here. Yes. Evening, y'all. Good evening. Good evening. Good evening. Hey, T-Rex, how you doing, brother? Hope you're doing well. Good to see you. Good to see you, Tammy Bugard. Oh, wonderful. Wonderful. Glad you could make it. You guys ready to finish out the Edgecomb shenanigans? We're getting pretty damn close. We got a couple of things that are going to be in front of the folks here. Let me see if this will refresh here. My whole computer card just glitched like crazy on me. I didn't know what it was at first. But that's why I had probably a shocked look whenever it came up, because like my screen was black and I couldn't figure out what was going on. It's weird how the computer is acting all funky lately. It has been just crazy. Let's see. And there we go. Send that out. Oh, that's wonderful. That's wonderful. So you're doing an interview with MLS on Friday morning. Shizzy, awesome! Congratulations. Have a good time with that. I hope you enjoy. Hope you enjoy. MLS is somebody that I'm sure can interview you really well, or you interview them really well. Rob's Finds. Good evening, everybody. Glad to be here. I'm glad you're here. Hello from Arizona. Yes. Yes. Hello from the Arizonas. Yes, we are right in the middle of getting this thing pulled back up. Like I said, my computer did some really funky stuff a minute ago, and so it seems to be working a little bit better. Well, I guess we'll find out. We'll just get this thing fired up and make it work. We may have some people join us tonight. We may not. It may just be you and me, chat, which is just fine. It's good to see all of you. Here we go. Well, let's bring up this right here is about 8-minute video, somewhere around in there. He's outside of the jury presence. So they're having some discussions about Edgecomb testifying in his defense. So let's get that happening here. Let me get my little thing up here that shows the get rid of that. And another thing I can always do is I could just do this right here. That gets rid of it, and then I can get rid of the overlay. But just in case I get those people that come in, it's good to leave it there. So that's what we're going to do. And let's make this thing wonder if I can do it like this. So I'm going to try to create a new layout. Now what I'm going to do is put me, how does it go? I'm going to put, what am I doing? Add item. Here we go. Add item, media slot. And we're going to put the media slot right about here and expand it out. So I think that'll work. I'm going to try something here. If you don't see it, it's only because I'm being goofy and silly. So let me see if I can make this thing expand out just a little bit more. Yeah, that should work. Or maybe it's this one. Yeah, that's gonna work. Bring it in right about there. And yeah. And then we're going to add another item to it, and let's see what happens. Add, let's see, a grid of dynamic camera slots that adapts dynamically to the number of participants on stage, up to 10. Okay. What we'll do is we'll just move this up here. Move this up like that into this space. And move it all the way across. Yeah, that should work. Or should I? I know what I can do. I can do it like this, like this, like this, and move it right center like that. Yeah, I like that. That could work. Let's see if I can expand this out any further. Maybe up. Nope. That is the best I can do with it. All right, that'll work. And we'll save that. And we're going to say, damn it, save the layout. There we go. Did that work? Yeah. There we go. Cool. I like that. I like that. Yeah, that may just work out. We'll see. We'll see. Hey, how's it going? Gutter Girl is in the house. Hey, Rosalind. Doing a couple of chores since I fell asleep for 3 hours during the storm. Well, that happens. You get a little bit of rest. I just saw the Gutter Girl. There you are. How you doing? Good to see you. Good to see you. Good to see you. All right. Well, let's get this thing on the road here.
Please look back in the record.
Wisconsin versus Theodore Edgecomb, 20 CF 3535. Appearances.
Grant Huber for the state.
Nico Lott on behalf of Theodore Edgecomb.
B.R.B. Lamar, on behalf of Theodore Edgecomb.
All right, it's 1:20. I'm going to bring the jury back in. The defendants on the stand will continue with cross-examination. Everybody.
Unless the state's not going to try to introduce this in its cross, but there was one issue that has to be taken up outside their presence.
Well, they're outside the presence.
What is that?
That's the assertion by the defense as to what the defendant's testimony would be in a prior motion.
Right, everybody use the microphones. I'll hear from the state.
Yeah.
Well, Your Honor, in a prior motion filed by Mr.
How arrogant is he? Is sitting over here texting on his phone, like he's not even paying attention to the judge. He's not paying attention to the proceedings. Like, how arrogant can you be?
Ahmad. He informed this court that, and these are the words in his motion, Mr. Edgecomb will testify at trial that given the nighttime hours and that it was dark outside, he saw the victim reach for his pockets before he shot him once. He further writes, while he did not see the knife as it was in the victim's pocket, he had reasonable belief that the victim was armed. The defendant's testimony is contrary to that assertion by the defense. The defendant is not stating that he shot because he saw the victim reaching for his pockets. In fact, he's actually saying he didn't even mean to shoot. Also, the assertion there is that they never saw the knife because it was in the pocket appears to be contrary to what the defense is attempting to insinuate. The case on this, Your Honor, is state.
Total time. He's not in custody and in court. He is the attorney. That's the attorney sitting there. So this guy right here, this B. Ivor Lamar, he is the attorney. And he's over there just on his phone texting away. Like not paying any attention to what's going on. Acting like he's too cool for school, and he just constantly is doing it. Yeah, he should be in jail. I showed your adopted mama, and she was floored.
State v. Cardenas, that's Cardenas, Hernandez, Hernandez.
Yeah,
that's 219 with 2nd 516 at 1998. In that case, the Court of Appeals adopted the test developed by the Second Circuit in U.S. v. McKeon. That's M.C. capital K-E-O-N at 738
Captions
F
happening here.
second 26, a Second Circuit case from 1984. In that case, the McKeon developed a three-portion test to determine whether or not an assertion by an attorney counts as, and this would be under Wisconsin statute section 908.01 sub 3, which is a statement offered against a party, and the big one is sub 4, a statement by the party's agent or servant concerning a matter within the scope of the agent or servant's agency or employment made during the existence of the relationship. Or, and this is number 3, a statement made by a person authorized by the party to make a statement concerning the subject. The three-part statement or three-part test that McKeon ends up developing in this case, and that is applied in Cardenas, is, and just let me find it real quick. Apologize. It is on paragraph 18 of the Cardenas-Hernandez decision. First, the circuit court must be satisfied that the prior statement is an assertion of fact that is inconsistent with the assertion at later trial. The inconsistency in the statements must be clear and of a quality which obviates any need for the trier of fact to explore other events at the prior trial or other assertion. Second, the circuit court must determine that the statements of counsel are the equivalent of testimonial statements by the defendant. There must be something beyond the attorney-client relationship to show participation by the defendant. Third, the trial court must, in a hearing outside the jury, determine by preponderance of the evidence that the inference the prosecution seeks to draw from the inconsistency is a fair one and that an innocent explanation does not exist. If the opposing inferences are of equal weight or the preponderance of the evidence favors the innocent explanation, I shouldn't be allowed to use it. So when we apply that three-portion to this, defense counsel, Mr. Ahmad, clearly stated that the defendant would testify that he shot because he saw the victim reaching for his pockets. That's not what he just testified to.
It's an argument made by the defense attorneys in a motion that was filed months and months ago that the jury doesn't know anything about, and I'd rather not invite an appellate issue. You're guaranteeing an appellate issue in this situation. You have plenty to cross-examine this witness on. He made all kinds of what are arguably inconsistent statements. He testified to things that are not consistent, potentially, with the defense opening statement. He said, to the surprise, I think, of potentially some, that all of a sudden the gun went off. Never once has the defense indicated that, ever. But that's what the testimony was. So why go down this path?
Your Honor, here's the reason why the state's asking me to go down this path. We have the defense counsel stating to the court and asking the court to make a decision and asserting what the defendant is going to testify. It would have been different had they argued it any other way. Defense counsel wrote in there, the defendant will testify.
Yes. Go ahead.
Judge, so looking at the second factor, it says, sorry about that. Yes, looking at the second factor, it says it has to be something beyond attorney-client relationship that shows the participation of the defendant. In the case they're relying on, it was an opening statement by counsel, which you would assume counsel would prepare with his client for that, and he's representing what the client will testify
That's
to at the
about
opening.
right.
This was a
That
bond
is so
motion.
right.
I don't even think Mr. Edgecomb saw this. This was just my review of the evidence. I'm talking prior to it being submitted, okay?
The defense counsel wrote, the defendant will testify. If he's saying,
Hang on. When?
Judge, this was filed this summer, many months ago, and
And the state knows, I mean, the defendant's testifying. He's testifying, hopefully, honestly and truthfully. He was sworn to tell the truth. Everybody knows that, it's a live event. Hopefully, the defendant's testifying truthfully. But the testimony that comes out rarely, if ever, can be predicted word for word, and you're going to have plenty of time and plenty of things to cross-examine him on. I'm denying that request. I'm sustaining the defense objection. It's arguably attorney-client privilege. It was just, in my view, hyperbole in a motion. It was filed 6 months ago or 3 months ago. You're opening up a huge can of worms in front of the jury. It has the potential to confuse the jury. I'm not holding the defense accountable for something they argued rightly or wrongly in a motion that I denied, by the way, 3 to 6 months ago. So I'm sustaining the defense objection. Let's bring the jury in. State can start to cross.
Sorry about that. Let's continue on with that. No, we're not frozen. Not at all. Sorry about that. Yeah, so that's basically what they did is they kicked that thing out and they said, no, we're not going to allow it. So that was that one. And let's go ahead and go to the next day. This is going to be cross. It is about an hour. It's about an hour of cross here. And then there's going to be some more arguments and there will be a recross. So we should be able to get it all covered tonight. That is the goal. That is the goal, to get everything of this covered tonight. Maybe we can put this thing to rest. Hey, Daniel Barry, how is it going? Good to see you, Daniel Barry Sports Highlights. Oh, yeah. Yeah. Yeah, I had to pause for a second. It's okay. It's okay. So here we go. Let's present this thing back up and carry on with it.
All right, Jerry's coming in.
Goes.
Everyone can remain seated, please.
Mm-hmm.
Every time you guys come back from lunch, I sit here with bated breath, hoping no one got food poisoning from the cafeteria. Again, we made it today. Let's continue. The state's going to start their cross. Mr. Gibner.
It just kills me.
Sir, I have a few questions for you. I'm going to try to keep them fairly quick here. To begin with, on the night in question, you were armed with Ruby Mizzle's firearm, is that correct?
Yes, that is true.
And this was a firearm she bought, is that correct?
Yes, that is true.
And were you legally allowed to carry a firearm that night?
Overruled. We've discussed this previously. You can answer. It's a yes or no question.
Yes, that is true, but I have accepted responsibility for those actions.
Understood. Were you legally allowed to carry a firearm that night?
Yes or no?
I have accepted responsibilities for those actions.
Understood. Wasn't my question. Were you legally allowed to carry a firearm that night?
And he's going to repeat this multiple times the same way. His testimony is so frustrating. Yeah, guilty. Yes, we know that he's guilty. He knows he's guilty. And this is going to be one of the most aggravating parts of this. Just so you guys know, it will be one of the most aggravating parts of this whole testimony, because this is the way that he answers every single question.
No, I did so
Thank you.
though.
Thank you.
Yes or no?
Thank you, sir.
You will continue to ask questions, and your attorneys will get a chance after that. Go ahead.
So that night, on your way to go get sushi, you grab this 9mm handgun, is that correct?
Can you repeat that question?
You're going on your bike to go grab sushi, and as you're leaving, you decide to grab Ruby's 9mm handgun, is that correct?
Yes, that's correct.
Okay. And when you drove your bike over, heading in this direction, getting towards Brady Street, you actually came up those stairs that you went down, is that correct?
I'm not sure in which the pathway in which I took.
And if there's video from Swing Park that shows you walking up up those stairs with the bike, you don't remember how you got up there?
Not right now, I don't.
Okay. And then you walked your bike past Zena's, is that correct?
Yes, that is correct. I do.
And you walked your bike past Casablanca, is that correct?
Yes, that is correct. Before
And you-
the incident.
I understand, so just listen to my question and it'll be quick. And then you walked your bike down to the sushi place, is that correct?
Yes, that is
All
correct.
right. Now, I want to fast forward. I'm going to come back to some portions of that, but I want to get to the portion after you have shot and killed the victim in this case. You went down the stairs, is that correct?
Can you repeat that?
After you shot and killed the victim, he falls down to the stairs, he's bleeding out. You take your bike and you walk down those stairs, is that correct?
I reacted in self-defense. I didn't.
That's not my question, sir. My question was, after you shot and killed Jason Cleereman, did you pick up your bike and walk down those stairs?
I reacted to protect myself from
Sir,
being
that wasn't
harmed.
my question.
Mr. Edgecomb, you need to answer the questions that are put to you. This is not a time for speeches. You're to answer Mr. Huberman's questions. After he's done, Your attorneys will get another chance, and then he will get the last word on recross. Answer his questions, please.
Hey, Catherine.
You understand?
Yes, Your Honor.
Okay. So
Yes.
after you shot and killed Jason Cleereman, you picked up your bike and you walked down those stairs. Is that correct?
I reacted to protect myself from being
Sir,
harmed.
I need you to listen to my question. We're not talking about the man. I'm talking about what happens after you shot and killed him. Regardless of how you want us to believe it, which is fine. They'll be able to get up here and do that. Listen to my question, please, sir. It'll go quicker for both of us. After the shooting, you pick up your bike and you walk down those stairs. Is that correct?
Can you repeat that again?
Sure. After you shoot and kill the victim, do you pick up your bike and walk down the stairs?
I reacted to protect myself from being harmed.
Sir, you're not answering my question. And I understand. I mean, did someone tell you just to say that whenever I say anything?
Can you repeat that?
Did someone tell you to just make sure you keep saying that you reacted to protect yourself when I ask a question about shooting the victim?
No.
Okay, so since that is now where we're going with this, let's just concentrate on what I'm talking about. After the death, whatever the category is, and we'll get back to that later. You pick up your bike and you go down those stairs, isn't that correct?
I didn't learn of a death until days later. So.
Understood. Did you pick up your bike and go down the stairs?
Can you, I don't know,
After the incident?
You can't.
Where, did you pick up your bike and walk down the stairs, sir?
after the incident, yes, I picked up my bike and walked down the stairwell.
Yeah, you're about to reach through the phone and slap him. I know the feeling. This is one of the absolute worst. Him trying to defend himself is so horrible. It is so bad. By the time they are done questioning him, you really are going to want to slap you would not want to be on that jury, because I think the jury would just be like, oh, for the love of God.
Thank you. Did you put the gun away first?
Yes, I did.
And where did you put the gun?
In my waistband.
Okay. And when you go down those stairs, you get down to Water Street there. You end up turning right, isn't that correct?
Yes.
And you stated that you went away from the scene because you thought that maybe these cars, people might be coming to get you, isn't that correct?
Yes, that is correct.
Now, had you gone left on Water, you could have eventually gotten to a police station, isn't that correct?
I'm not familiar with any police stations in the area.
You're not familiar with District 1, which is kind of, you take Water down to State Street, you can kind of get right here. You're not aware of the huge, big white building that says police on it?
No.
Okay. So,
Oh, shit. That's all putting it there. You just say it. Oh, I'm sorry to hear that. I'm sorry. You had to come stay with your son. Power is out at home due to rainstorms. Oh man, I hope the power gets to happening back again. That's never any fun.
you turn right. And as you're going right, you eventually get to that red light on Humboldt, isn't that correct?
I can't recall right now. It's not recollecting with me.
It's not
You saw some of the
recollecting.
video, but you don't remember stopping at that red light and then eventually riding through the red light that we saw earlier in the trial?
Yes, that is correct. I do remember.
And there's a bar right there, isn't that correct?
I can't recall that, no.
And there was a taco place on the other side with some people hanging outside, isn't that correct?
I can't recall that at all either.
And you didn't go into any establishment or talk to any of those people to ask for help or say you needed help from the police, did you?
Any people where, sir?
As you're fleeing the incident on your way home.
I was in a state of shock. I couldn't believe what had just taken place.
You couldn't believe you had just shot someone, correct?
Can you repeat that?
I'll move on. So, when you get to Humboldt, quickest way for you to get home would have been to take a left and go north on Humboldt, isn't that correct?
At which point?
When you're at remember where we saw in the video where you're at the red light, there's Rat Fangs in the Bel Air Cantina, and we saw you kind of just sitting on your bike? You remember that location?
I don't remember which establishment I was by, but I remember, like, at what point, at some point, right?
it gets worse.
I don't know where exactly that was, though.
Had
Yeah, it
that
gets
been Humboldt,
worse.
if you had
Oh,
taken a
trust me.
left, you could have taken Humboldt all the way up to Locust, couldn't you?
At which point, sir?
And where you were stopped on Humboldt and Water.
At which point are you referring to?
After the shooting, when you're fleeing away, and we saw you on the video, stop at the stoplight.
I don't remember what intersection that was.
Okay. And instead, you end up taking kind of that bike route, is that correct?
I do remember being on the bike pathway.
And when you get out of the bike path and you get up on the Locust, and you end up biking to your house on Dousman, isn't that correct?
Yes, I do remember that.
And if you had kept going on Locust, you could have gone to a police station, isn't that correct?
I don't know of one there.
I was in total shock at what had just taken place, so I wasn't really thinking as far as, what to do next.
Understood.
They're just, oh God, they're just laying it out there like, there's a police station right here. 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 At any point, did you decide to stop and seek help from anybody? No, it's not reading the Solvsit manual. This is how his attorney coached him. Where's the women's? Hey, the women's got the invites. They comes whenever they comes. You just have to moisten them up really well. That's all.
Well, you stated you were fleeing because you thought people might be out to get you, correct?
Yes, that's true. I was in shock and in fear.
Okay. And so when you get
Yeah.
out there on Locust, you could have gone
Exactly.
straight to that police station.
That's the point.
In order to get some help, couldn't you?
There is a police station on Locust.
Thank you very much. Instead, you went home, isn't that correct?
At that point in time, I wasn't thinking to go to the police station. I was in a state of shock, so to think,
You're in a state of shock,
Wasn't-
but you don't want to go to the police.
it wasn't.
You went home, isn't that correct?
Oh yeah.
Yes, that is correct.
And when you went home, you put the bike down in the basement, isn't that correct?
No, that is not correct, sir.
Someone else did.
I don't recollect what I did with the bike. I was still in a state of shock.
But you left the bike at your house because we see you walking. You left
I love it.
you left your house on foot, isn't that correct?
Yes, that is correct.
And you left your house on foot with a backpack, isn't that correct?
I don't cross the
Yes.
streams.
Did you still have the gun on you?
At that point in time, I can't recall.
So you don't know if you left the gun at Ruby's or if you took it with you.
That is correct. I don't recall.
And you take this backpack and you go where?
At that point in time, I went to a friend's house, and I actually, I went to a friend's house and, told them I had a family issue that was going on. I didn't want to get into details about the incident that had just taken place.
Now, you
Yep,
said you went to a
because
friend's
they
house and
would've
told you you
turned
had a
your ass
family
in.
issue.
What is that?
I mean, it's a little bit of a lie to your friend, right? Yes?
I don't know if you're asking the question or you're
Yeah,
making
no,
a
I said,
statement.
right? I'm sorry. You kind of lied to him, right?
Can you repeat that question?
All right. How about this? A couple days later, you met with certain family members who said goodbye to you as you were getting ready to leave the state, didn't you?
No, I don't know what you're referring to, or what are you?
Do you not remember on the 24th or the 25th of September, meeting with,
25th of September.
do you know who Katrina Gordon is?
A day I'll always
Yes.
remember.
She a cousin of yours?
Yes.
And isn't in fact, she and other cousins of yours met with you to say goodbye to you because you were going to leave the state for Florida?
No, that is not true. That is not true at all.
Now, how many days before you took off from Wisconsin?
It
Well,
was in
immediately.
approximate around October, like mid-October, so
I don't know. Have you asked her how she's doing today? I mean, she seemed like she was doing okay. She had if I'm not mistaken, that she did a stream with Megan Fox today. And I think she did a morning stream also. I'm hoping that she's doing good. Well, the sushi's still waiting on him. That's what's going on.
yeah. I
So-
can approximate what, like maybe a week.
A week.
About a week, you think? Was it about a week, you think? Is it right? Do I have that right?
Yes.
Okay. Let me help you out with this. Was it before or after the police executed a search warrant at your residence looking for you?
I had no notice of a police warrant or Yeah, I had no notice of it.
Ruby never told you that we hit the house looking for you?
Yeah, afterwards. I didn't know prior.
Okay. So, let me find out, when Ruby tells you about the fact that the police hit the house looking for you, had you already left?
Can you repeat that?
When you find out that police had executed a search warrant at your residence,
Throw your
did you find out while you were still in Milwaukee or
tomatoes.
while you were in some other state?
Can you repeat that again?
Where were you when Ruby told you that they hit the house looking for you?
I was at a friend's house.
Where?
I was still in Wisconsin.
So you're,
But I
still,
hadn't, go ahead.
you're still in Milwaukee?
Yes.
Okay. So,
If my recollection serves me well, yes.
now,
Oh, yeah. Yeah, I think she's doing just fine.
when do you get the gun back?
I don't remember if I left it or if I had it on me, at this point in which year. I don't know in which time year. Yeah, I don't remember.
Huh.
So at some point, you're in a car getting to the Illinois-Indiana border, and you throw it out the window, is that correct?
Yes.
You knew it was evidence of the homicide, isn't that correct?
I knew that as far as, like, I just didn't. I didn't.
That's awesome.
Can you repeat that again?
That too. That's
You
true.
knew that this gun, if you were caught with it, could link you to the homicide, isn't that correct?
I reacted to protect myself. I didn't.
Again, I understand your refrain, sir. I want to concentrate on what I'm talking about. When you tossed that gun out the window, you knew it was evidence as to your shooting that you had done, isn't that correct?
It was a reaction. It wasn't just a shooting.
Oh, what just a shooting?
Mr. Edgecomb, you need to answer the questions. Don't give speeches. Answer the questions that are put to you.
You tossed the gun
Good evening, Debbie
knowing
Moran.
that it was evidence in what you had done, isn't that correct?
Yes, that is true.
And you don't remember if you had this gun the entire time while you were hiding out, or if you went and got it back after leaving it somewhere? You don't remember that?
I don't remember the point in time in which I did have, get it back.
Why take it to another state to toss it out the window?
At that point in time in which it did happen, I didn't want to have it on my possession and, have someone, a citizen or law enforcement kill me and being justified in that.
Okay, understand that, but you waited 2 states before you were worried about that. Correct?
Can you repeat that?
You're stating that you got rid of the gun because you didn't want to get caught with it, because if you had a gun, maybe someone would say you were armed and they might shoot you. Is that kind of where you're going with this?
Yeah.
Say that. Can you repeat that one more time?
You tossed the firearm because you were worried that if you had it on you, you could get shot due to that, right?
That someone would be justified in killing me because they said I was the Brady Street killer, so they would be
Understood.
justified in.
Understood. Then why wait to Indiana? Because doesn't that fear exist in Illinois?
It was actually in the border between Illinois and Indiana. It was a body of water, and the thought just came to me like spur of the moment to do so.
Up until you see a body of water at the Illinois-Indiana border, the thought happened. You were holding on to that gun, no problem.
Yeah.
Can you repeat that?
You don't have this thought until you get all the way through Wisconsin, through Illinois, and to the border with Indiana. That's when you suddenly realize you got to get rid of this gun for your safety?
It was like a spontaneous thought.
Sir,
Oh.
isn't the real reason you waited to Indiana was because the chances we'd find it go out the window?
No, that's not true.
Matter of fact, we have only your word that the gun was even thrown there. Isn't that correct?
Can you repeat that?
We only have your word that that's where you threw the weapon out. How about this? Let me rephrase it. Was anyone else in the car with you?
No.
So the only person that knows where you ditched this weapon that shot Jason Cleereman in the face is you.
I reacted
was
to protect
acting
myself from
myself
being
in
harmed.
defense.
I get it, sir. The only person that knows where the gun is you. Isn't that correct?
Can you repeat that?
The only person who knows where this firearm was thrown out the window is you. Isn't that correct?
Yes, that is correct.
Thank you.
It's like
When you're biking
just want to
away from the
slap him.
scene, you could have thrown it in the river there, couldn't you?
I was in a state of shock. It didn't cross my mind to do so.
It didn't cross your mind until after you've been hiding out for a week and decided to flee the state and got 2 states away. That's when it occurred to you to throw this gun out the window. Do I have that correct?
No, that is not correct.
Well, let me move on. You also indicated that the reason you went onto the run into other states was because you were waiting to see if you could get legal representation. Isn't that correct?
And to also seek funds to help with my defense.
Okay. Now, did Ruby ever come visit you in any of these other states?
No.
What other states did you go to?
Only Georgia.
And Ruby rented you the car that you were driving. Isn't that correct?
No, that is not correct. In fact, she already was in possession of the vehicle, so she didn't rent it for me.
So she got you the car, though, correct?
No, she was already in possession of the vehicle.
Then how did you get it?
I asked her, if I could use it. I needed to seek a way to get finances. So,
Was that the car that you were driving when you threw the gun out the window?
can you repeat that?
The car you got stopped in Kentucky, the one Ruby rented, was that the car you drove to the Indiana border and threw the murder weapon out the window?
I reacted to protect myself from being harmed. I didn't murder.
Understood. When you are driving this vehicle, is it the same vehicle that Ruby rented for you that you get stopped in Kentucky with?
I want to take a step back because you're saying
No.
that she rented the vehicle for me. It wasn't rented for me.
Understood.
She was.
Is it the same car? Are both cars the same car?
Can you repeat that question? You said like 3 different things just now.
Okay. Sorry, I'll rephrase the question, Judge.
Well, the defendant does not ask questions, he answers questions. For you and for his own attorneys, he will not ask any further questions in this court. Go ahead.
Sir, the car you drove to Indiana, the one where the gun goes out the window, is that the same car you got stopped in Kentucky driving?
Yes, that is true.
Okay. And so, Ruby gave you that car, isn't that correct?
Yes, I borrowed that car from
And
her.
did you tell her you were going to be leaving the state?
I told her that I would, need to go get funds. I didn't tell her where I was headed.
Okay. And so she gives you a car, you're intending to leave the state. I want to make sure I have that right. All of this happens after you find out the Milwaukee Police Department has just hit your house looking for you. Isn't that correct?
I'm feeding them to
Can
the
you repeat
gators.
that?
Okay, so
right.
you get the car from Ruby, and you
really
leave the
wanna
state,
feed 'em
and you ditch the gun
gators.
out the window. That all happens after the search warrant at your house, doesn't it?
Son,
Can you repeat that one more time?
Sir, you got to understand this. You just told us that you were in Milwaukee when you found out the search warrant happened at your residence, right?
Yes.
Okay, so after you find out the search warrant happened at your residence, is that when you decided to flee the state?
I went searching
No,
funds.
that's not true.
Okay, so is that when you decided to get out of the state with the gun and make sure we never find it?
Can you repeat that? Because you.
Sir, it's the same question. Is that, once you found out that we hit your house looking for you, is that when you decided to borrow your girlfriend's rented car, drive out of the state, and toss the gun out the window? Yes or no? Is that when you did it?
I
No.
did it in self-defense. No, he didn't
Now-
do it then.
You stated that you had to leave the state to buy yourself time to get legal representation, right?
Yes.
But you had 2 lawyers at that time, didn't you?
At which particular time?
At the moment of the shooting, the moment you fled the state, you had 2 lawyers.
Oh, ladies and gentlemen, one of my favorite people, and there's only one that's like this kind of person that just makes you do this right here.
Wow.
Hey, Rosalind.
I had no idea.
He's just like, yeah, showing shoulder for bad duck. You're just here to tease and taunt him.
It's just kind of my look. I promise. Like, one, I don't like t-shirts like that are crew neck.
Well,
I feel like I'm getting choked.
you don't have to wear a shirt here. It's totally fine.
Well,
Of course, then Bad Duck will never leave. He'll be stalking you all over the place. Someone clean the cream corn out of this guy's ears. Oh yeah, he does this throughout this whole testimony. It's so hilarious. So how you doing tonight, Rosalind?
I'm doing pretty good. I'm pretty well rested.
It's funny because I was on with MG for a little bit last night and hung out there and chatted with midget. Damn it, I forget her name. I'm so bad with names. Kinsey. Yes. And then I came back and did a stream this morning, and of course Brandon, let's go Brandon's just like, do you ever sleep, dude? Like I swear to God, like you were on MGs, and then I wake up this morning, here you are doing this again. It's like, are you okay? Are you safe? I was like, no, I get plenty of sleep. I really do. It's amazing how much sleep I get. Sometimes I think I get too
my
much.
little dog, she's older, but she's terrified of storms. So the only way to calm her down is to curl up with her, and
Aw.
doomed to fall asleep.
Yeah. Yes. Ours does that too. He's a Chihuahua Dachshund mix, so
She's a Boston Terrier Italian Greyhound mix.
nice.
So nervous.
Yes. You're always on my mind. You were always on my mind. Oh, so what have you been watching this so far?
Yes,
Oh,
I've been listening while I was getting my stuff done.
Don't you just want to slap this guy?
Yeah.
Just
Oh yeah.
just like, oh. Yeah, could you repeat the question? Can you repeat the question? Can you repeat the question? I was defending myself, and it's like, and then as soon as his attorney gets up there, it's just, he has no problem answering those questions.
Right.
Didn't you?
Can you repeat the
Not
question?
right. I don't know.
Well, you had one case with an attorney, Anna Keys, didn't you?
Objection, Judge Sidebar.
Yeah, these are all things that he is. It is quite annoying. This guy is such a pain in the ass. Judge is like, you better get your client under control and have him start answering questions. B. Ivory Lamar
You had a case.
prepped him to act this way.
Right.
And the reason that he did it is because he's got no defense. It's just
it doesn't look like
delaying. And this way, B. Ivory Lamar can charge more per hour. And he's tapping into funds that would have been donated to this guy's defense. Could you imagine that? Being that much of a shitty attorney.
No.
That you cut, quit talking mean about me. Oh, the video. What do you sidebar, Mike? Oh, I would love to just pick Borowski's mind on that, on his thoughts on this whole case.
With an Anna Keys, that's ANNAKEES. Isn't that correct?
I do recall that name.
Okay. And in fact, she had a court appearance where she was waiting on you on October 19th of 2020. Do you remember that?
Yes.
And you didn't show for it, did you?
No.
Because you were on the run in another state. Isn't that correct?
At that point in time, I don't remember or recall where I was at that exact date.
Oh, you're saying you weren't there?
Well, once you left the state of Wisconsin, did you come back ever?
Yes.
How many times?
I don't recall right off.
You
Don't recall.
came back into the state of Wisconsin?
At which particular time?
Anytime. Anytime between the moment Jason Cleereman dies and Kentucky finds you.
Yes.
How many times?
Only that I recall, it was only, twice?
Didn't make your court appearance when you came back though, did you?
They were all via Zoom. None were in person.
That doesn't change the fact you didn't show up, does it?
I didn't mean. I was trying to understand your question.
Understood. Did you
said
show up for
so
your, did you show up for your court date?
Those court days, no.
You also had another attorney on another case, a Megan Koldunski. I apologize if I mispronounced it. Kaldunski. You had her too on another case, didn't you?
I'm not sure if these lawyers were even criminal defense lawyers.
Oh. Oh, yeah. Broski pulls him aside. Sidebar. And he is going to say, listen, you need to get your client to start answering these damn questions and stop avoiding it, or I'm going to hold you guys in contempt of court for prepping him this way. I would just like to protest and say you were always on my mind.
Stake and proceed.
Did you just state that you don't believe that those two witnesses or that those two lawyers were criminal defense attorneys?
There, does that make you feel better,
Yes,
Bad
to my
Doug?
knowledge, I didn't know.
So didn't they represent you on two open criminal cases?
In matters,
Okay,
like I'm not knowledgeable if, you know, as far as,
heart breaks
if,
every time.
you know, like how can I say,
If I break.
how they differ in different matters.
You had two open cases in criminal court with court dates, and these were your attorneys, correct?
I'm trying to, because I don't know if they handle matters.
I don't really know how to answer this question because it makes me look bad, like I did bad shit. And, well, do I have to answer questions?
Can't remember what I've lied about yet so far.
Yeah. Can we just change the subject? Can we talk about something else?
Can we go back to Froyo?
Yeah, I just wanted sushi for my daughter. See, that's the stalker's anthem. Yes. Oh, can't you see you belong
Thank you,
to
Bad Doug.
me? Oh, how my poor heart aches with every step you take, every move you make.
We were really
Every
stalkers in the
vow
80s.
you break, every smile you fake, every claim you stake, I'll be watching you. Yes, that is the stalker's anthem.
For
in
sure.
which, you know, are, you know, to the extremities which they handle different matters.
Understood, but
the-
that's
to
different
the
than saying you didn't know they were
extremities?
criminal defense attorneys.
Yes.
I mean, they represented you in criminal cases, correct?
I like this guy.
Yes.
These
Huh?
two
Can you ask that
attorneys
question
were
again?
representing you in two open criminal cases, weren't they?
That's what I don't understand the degree, even of the matters that you know, as far as what you're referring to, as far as with me.
You don't know the two cases I'm referring to?
No.
Do I need to refresh your memory?
Yes, open the door. We just discussed about the record.
Defeated.
The testimony opens the door to continue cross-examination.
So you had,
See him being a dumbass like this, the attorney he knows how to ask these questions in such a way that he opens the door to it. And they opened the door on this. The defense has opened the door. His defense attorneys opened the door on him being prosecuted by other cases because they were trying to get ahead of it.
Right.
Now he doesn't want to answer the questions. And this just makes him look so bad.
Well.
Yes or no, MF? In Samuel L. Jackson voice. Be right back. I don't want to miss this. Oh, well, we can delay it for just a few seconds. Go take yourself a potty break.
Go uncork.
Oh my God. No, it is so amazing to me that, and you know, whenever somebody has done something shady, you know, whenever somebody's pulling something shady, because the way that they answer the questions, they won't answer the questions directly. This is the same thing that Fannie Willis did. This is the same thing that her lover did. This is the same thing that this guy is doing. No different than the way that anybody that is doing has done something illegally and bad and horrible will answer questions. It doesn't look good in front of a jury. They don't realize that the jury is just like, for the love of God, answer the damn question.
Right. They're tired.
Answer the question, and you can say that, I feel remorse for what happened. It was a bad way to go, but you don't have to continuously repeat it. That's not doing any good. And all it's going to do is going to piss off the judge, going to piss off the jury, going to piss off the prosecution, and they're going to be less likely to give you any sort of slack. Like, they will dig in deeper because, we're not here to play the game. Like, it might work out in the real world where nobody's getting hurt, but in court, where law is law, facts are evidence. Don't play this bullshit. Hey, Indigo, how you doing, you little sex muffin, you? Good to see you.
So the case with Anna Keys in Waukesha, you realize that was a criminal case? Is that correct?
I didn't know if they would be able to represent me, so I didn't deem them.
That's not the
deem
question.
her, or even to, let her know of, the matters at hand because of the extremity of it. So I wasn't knowledgeable in how to acquire, as far as, I didn't even know if they were qualified in the matters that were at hand. So
Did you call them?
I called different attorneys.
Wasn't my question. Did you call the two attorneys you had in open criminal cases in Wisconsin?
Not at the time, I didn't.
At any time?
There were at times when they were contacted due to the matters that were at hand involving those situations.
And you ended up, just so we're clear, in the Waukesha matter, you didn't show up for your Zoom October 19, 2020 hearing. Is that correct?
Can you repeat that for me?
Sure. Your case with Anna Keys. You were supposed to be on Zoom court, as you stated, on October 19th, 2020. And you didn't show up, did you?
No.
And your case in Milwaukee with Megan Koldunsky, you had a date in January of 2021. You didn't show up for that one either, did you?
Yes or no?
As I recollect, no.
Now, sir, when you finally get pulled over, this is after you dyed your hair in an attempt to not appear to be yourself. Is that correct?
I don't want to be taken into custody involuntarily, and plus, I was in.
Okay.
I didn't want to be taken into custody involuntarily. Well, then why didn't you turn yourself in would be sort of my next question, because then it wouldn't be involuntary. You would be voluntarily doing it.
Right.
No, you just didn't want to be taken into custody, which
Period.
means you were running from the law. Just like, okay, that's it. I'm releasing it. Bad Duck Puddletown loose. Oh, yeah. Yeah. I love it.
In fear of even going into custody.
Understood. Just if you could answer my question. You changed your hair so the police wouldn't find you, correct?
That is correct.
And when the Kentucky trooper pulled you over, you lied to him about your name. Isn't that correct?
Yes, I did so
Thank
just
you.
so I wouldn't.
Thank you very much, sir. And then you also lied to him about where you were going. Isn't that correct?
Can you repeat that?
You also lied to the Kentucky trooper about where you were going. Isn't that correct?
I told them that.
Yes or no?
You told him what?
Yes.
I just didn't want to be taken into custody involuntarily. I didn't have any.
So you lied to him about where you were going. Isn't that correct? Yes or no?
Yes, sir, that is correct.
Thank you very much.
There
And you
you
lied
go.
to him about where you were coming from. Isn't that correct?
I don't recall him asking me where I was coming from.
Do you remember telling him that you were going from Texas to a place in Kentucky?
I don't recall that.
If you had told him that, that would have been a lie. Isn't that correct?
Can you repeat that?
If you had told him you were coming from Texas, that would have been a lie. Isn't that correct?
That would have been, but I don't recall saying that.
Understood. So if you
don't
told
care if
the
you did or
trooper
not.
that you were coming from Texas, that would have been a lie. Yes or
We
no?
have it on tape.
Yes, that's correct.
Thank you. Now,
Thank you, dumbass. Thanks for wasting our
two
time.
detectives from Milwaukee Police Department come down to Kentucky to talk to you. Isn't that correct?
Yes,
And they tell you that they are Milwaukee police detectives and that they would like to talk to you about what happened in Milwaukee. Isn't that correct?
yes, that is correct.
And you acted as though you were unaware of what had happened in Milwaukee. Isn't that correct?
I didn't expound because I didn't have legal representation.
Didn't
Sir,
expound.
you stated what happened in Milwaukee. Right?
Yes, that is correct.
So you were acting as though you were unaware of what had happened in Milwaukee. Isn't that correct?
I didn't expound on.
Sir, that's not my
talking
question. My question was, were you acting as though you did not know what happened in Milwaukee?
No, that's not correct.
Oh. Wait until
I
we
just
play
want
the
to
tape.
make sure I understand this here. You fled from the scene, correct?
From,
I was
Homicide scene. You fled from the scene, isn't that correct?
acting in self-defense.
Yes or no, sir?
I was only able to get away from there, dude.
So you fled from that area, isn't that correct?
Yes, I did leave from
And
that
then,
scene.
thank you. And then you fled from the state, isn't that correct?
Are you? Yes.
And then you ditched the weapon that would have linked you to that shooting, isn't that correct?
Overruled.
His attorney
Can
should
answer-
have told him to ask for
You ditched the
water.
weapon that would have linked you to that shooting, isn't that correct?
Good grief.
I know. I plead the
I didn't
fifth.
want to be.
Sir, you ditched the weapon that would have linked you to the shooting, yes or no?
Can you expound on this?
No, sir, that's the question. Did you or did you not?
No, can you ask it in a different way that doesn't make me look like I ditched the weapon that I was carrying?
Yeah,
Can
Can
you
you ask
do
it without
that?
using the word ditch?
Slingshots be yes. Would slingshots be okay, Shizzy? I mean, I have got a pellet gun that's going to be on its way. It is going to rid my yard of some varmints really damn quick. But I have to wait until I get back from Florida. Damn it. And I won't be recording that because I don't want to get struck by YouTube for like promoting violence or something like that.
Right.
But I may have like a little body count. have a bounty on those damn squirrels.
You could just make little popsicle stick crosses in your yard.
No, I'll make some for the stream, like for everyone that I get. Just like you'll see them just start racking up here. Just be like,
There you go.
Be like the Red Baron or something.
Exactly.
Not throw the weapon that would have linked you to this homicide out the window.
I reacted to
What?
prevent myself from being harmed.
I understand that, sir. I understand the refrain that you have rehearsed. I want to concentrate here on the fact that after you left the scene and then left the state and then ditched the gun and then lied to a Kentucky trooper, that's when you decided to say, what happened in Milwaukee? When the police asked you. Isn't that correct?
I just didn't expound on them questioning me because I didn't have legal representation.
I didn't expound on
Well, I
that.
mean, you had two lawyers. You just
Questioning
decided
me.
not to go to them. Isn't that correct?
Oh. Oh.
He-
Yeah,
okay,
two lawyers, but you
It's
were
not
going
as
to
bad as that. What was his name? Yawn.
Bradley Yawn. Oh God,
Yeah, Bradley
yes.
Yawn. Like that guy just destroyed the English language. But this guy's really a close second.
Yeah, Bradley Yawn. That is one person that I was surprised wasn't deleted in the courtroom.
He was what?
Not deleted in the courtroom.
Oh, right.
It was that was probably one of the roughest trials I had
that
to
was
watch.
rough. Yeah.
explaining what he did to that old woman,
Mm-hmm.
the husband, talking about it, and then being cross-examined by Bradley, the
Right.
restraint that family had.
Remarkable.
Just like, I don't think I could have been that nice.
No.
Slap this dingleberry again. Yeah, he is a dingleberry.
In the matter that was at hand.
Okay. Now, I want to talk about this incident. This incident that finally, after all of that, you're now here for. You indicated you're going to get sushi, correct?
Yes,
Okay. And that restaurant is on the north side of Brady, isn't that correct?
yes.
And then you decide to go to Frozone, isn't that correct?
I never made it to Frozone.
Wasn't my question. You decided to go to Frozone, isn't that correct?
Yes.
Okay. And you got on your bicycle at that moment, didn't you?
At which point?
When you leave the area of where the sushi place is to go to Frozone.
Yes.
Okay. And you were going to head eastbound on Brady?
To head to Frozone, yes.
Okay. And you end up not going that way, do you?
I'm not going to Frozone?
Yes.
Yes, I never made it to Frozone.
You turn around, isn't that correct?
Yes.
And you're stating that as you're heading back westbound, that's when this incident happens, according to you.
Yes, that is correct.
Okay. Now, the car that you're stating, like knocked you and forced you onto another car, was that coming at you or coming from behind you?
They were actually more on the side,
Okay, were they heading the same way as you or were they heading towards you?
the same direction.
Okay, so they were behind you and kind of going up past you, according to you.
Yes.
And you had moved, I just want to be very clear, where was this when this happened, according to you?
It was, I can't pinpoint the exact location, but I know that it was like,
It was where no cameras could catch me. That's where it happened. Where the cameras didn't catch me.
Yeah.
Yeah.
maybe 2 blocks away from Dynamite.
Okay, so we're
2
gonna,
blocks east.
2 blocks east of Dynamite?
Yes.
Okay, so if we're going, and I just want to have this, Your Honor, I'm going to use Defense Exhibit 5.
Fine.
If we're looking at Dynamite, and we see here is Dynamite on Brady, is that correct?
That's what it appears on the map.
Okay, you're saying you think you went 2 blocks, this happens 2 blocks east? So like towards the right as we're looking at this?
Yes.
Okay, so it doesn't happen anywhere around this Glorioso's, right? Which is across the street from Dynamite, according to you.
It's an approximate location. I can't pinpoint exactly where it took place.
It's kind of hard to pick an exact location of where, like, something happens on the street, right? You don't know exactly where this happened, do you?
I know from as far as when my pace as far as like where I was on my bike. I know as far as like paces wise, but I know it had to be like roughly like, that's why I said an approximate, like 2 blocks away.
2 blocks away, so.
How many
2 blocks,
paces
this is
are in 2
Dynamite on
blocks?
Astor, 1 block would be Humboldt. You think it's
Yeah.
possibly even further east than that? Is that what you're saying?
That's why I said approximate. I never made it to Humboldt.
So it's further down east from this intersection with Dynamite. Do I have that right?
Yes.
Okay. Now, sir, you indicated that after this incident, you were pretty upset, weren't you?
Which incident in particular?
Or you just, what we just talked about, where you flip up on the car hood, according to you.
Yes.
Yes.
You were angry, correct?
I was a bit infuriated, yes.
Okay. In fact, your words on direct were, "I can't let them get away," right?
Can you repeat
I
the
don't
question?
recall saying that my exact words.
You don't
That's
remember
what he
stating
said on
that as they're going on, you thought, "I can't let them get away."
his testimony.
Yes.
So you did say that. That's what your thought was, right? You had just been wronged in your mind, and you were going to go after them because you could not allow them to get away, correct?
Yes.
Okay.
And I said that.
Well,
due
thank
to-
you, sir. These guys, they're great attorneys. They're going to come back and ask you all that stuff. I just need the answer to my question, okay? So you went after them, right?
I tried to catch up with them. I didn't go after them.
Oh, so
What's the difference?
I just tried to catch up.
one of them
hey,
makes me look like an asshole.
to meet up with them. I didn't like go after them.
Oh, you went to
like,
go meet up with them. Like you were going to go hang
They're
out,
ahead
have a
of you.
beer.
You can't let them get away. You're infuriated. You bike after them, correct?
to catch up with them.
Armed
Oh,
with a
to
gun,
catch up with them.
right?
That's not what he said.
Are you asking the question? Or you?
Yeah, armed with a gun, right? You got a gun.
Yes. At
Okay,
this point.
now, at that moment, you got to go past the sushi place, according to what you've just told us, right?
Yes.
Okay, so this place where you bought the food, where according to you, you're getting the food for daddy-daughter date night, you're going right past that to get at these two people, right?
Yes, that is
Okay,
true.
because you did not want to let them get away with what they had just done, saying these words to you, correct?
Wanted to see if they even acknowledged that they had hit me.
Wait,
You, sir, when you went up there, you didn't even bring up the hitting.
he needed someone to recognize, validate me. You didn't punch my time clock, so I'm going to punch you. Dude. Yeah, your dotty date night was so important you decided to chase someone down who said a word and you forgot your sushi. That's some anger issues right there.
You just said, were you talking to me, correct?
Did he?
As I was. Can you say that again?
You never mentioned this alleged getting hit by your bike. You drove up to them and said, were you talking to me, correct?
Yes,
Well,
and I was also
Thank
finishing
you.
the statement.
And then, when he said he was talking to you, you punched him, right?
Yes,
Okay, now,
I've accepted.
thank you very much, sir. So then, you punch this guy right in the face. And you bike off, right?
Yes,
Back going to the stairs that you'd come up on your way from home, correct?
I don't recall which pathway I took to get to Brady Street, if it was up the stairs or the ramp.
Sir, did it ever occur to you that the man you just punched in the face might feel the same way that you had felt just moments before? That he couldn't let you get away? That he wanted to talk to you or confront you about what happened?
It was compound, I guess. You can break it up.
Did it ever occur to you that a man you just punched in the face might react the same way you had moments before?
Can you repeat that?
Did it ever occur to you that the man you had just punched in the face might react the same way you had moments before punching him in the face?
Well, he
That's a
shouldn't
bad
have.
question. Let me do this again. You didn't want to let him get away, right? You
What-
stated you didn't want to let these two people get away, correct?
Yes, that's correct.
And then that guy followed you because he didn't want to let you get away.
They actually chased me with the vehicle.
Yeah.
And
They
tried to
pulled
hit
up
me.
and stopped and got out of the car. So here's my question, sir. Do you think you have the right to chase after someone that has wronged you, but someone does not have the right to do that to you when you punch them?
I was getting chased down with the
Wasn't my
vehicle.
question, sir. Do you believe it is okay for you to chase after someone and punch them, but someone can't do the same thing to you?
I reacted to being hit. And
You reacted to being hit. So that's what happened. A guy, you say you get hit, you get thrown up on the car. Your reaction is to go after him, punch him in the face one time, right? Just your reaction, correct?
can you repeat that?
Your reaction to what you say occurred on this car was to chase after him, not let him get away, and punch him in the face, correct?
I just want to say this prosecutor is so spot on. He is so spot on.
It's making me crazy.
Because he's made it a very big point to get him to this level of saying you chased after this guy, you rode all these blocks, you found it so important because he disrespected you, he said something horrible, he ran you into a car, whatever it was, you found it necessary to chase him down because you were injured or hurt, or your fifis were hurt, whatever, it doesn't matter what the reason was. He wronged you in some way, and you found it so important to chase him down and hit him.
Right.
And in turn, he chased you down to confront you. And then you shot him. That's the point he's getting at. And Edgecomb knows right now, but he's not supposed to do that
Right.
because it's wrong. And he knows it's wrong, just like he knows what he did by chasing the guy down was wrong. But he feels like he should be justified because of whatever thing this guy might have said. Maybe attach the zapper to him, just yeah.
No, that's not what I'm saying.
Now, sir, you punched this man, and then he comes up and he gets in a boxing stance with you. Isn't that correct?
I didn't see him get in the boxer stance. I just seen him raise his hands up from his midsection, and it looked as though he was drawing up with a weapon, and it appeared that it was an item in his hand.
Hey, I'm sorry, he was appeared with what?
It appeared that there was something in his hand.
Okay, you said you saw him coming up from his midsection, both hands, and you think he has something in his hands?
It appeared that there was an item. I wasn't just fixated on that item because there were two other threats behind him as well.
You see the look right there in his eyes? Because he's gone off the cues that his attorney used to get him to say, oh, he had something in his hand. He had a knife in his hand.
Mm-hmm.
He was going to attack me. Oh, just use 2 car batteries instead of jumper cables right to the pair of the almonds. Yes.
Captain Kern, ouch.
Yes.
Understood. I want you to ask my question. He gets into that boxing stance. Defense counsel asked you about it. You remembered it when he asked you. I want you to remember it when I ask you. Did he get into a boxing stance?
It didn't appear as though it was a boxer stance. I just seen him draw from his midsection.
And just so we're clear, you've done this now 3 times, and all 3 times you've done it, you've had your hands clenched together in fists.
And it appeared that he had an item in his hand, and he lunged towards me.
You had an item in your hand. I understand you've got that. I want to stay right here. He's got his hands up. You can see his hands, right? What did the item look like, according to you?
It all happened so quick. I wasn't fixated on the item.
Oh,
So, you don't know what it was.
It was dark in that landing area, so I
Again,
couldn't.
you don't know what it was.
What?
No, overruled.
You don't know what it was, do you?
I can't, say or assume what the item was in his hand.
Agreed. You shouldn't assume. So, you think there was an item in his hand, but you can't even say there definitely was one, can you?
Yes, it appeared that he had an item in his hand.
Exactly. It appeared. You don't know for certain, do you?
I wasn't fixated. It was 2 other threats behind him. He was just the imminent direct threat.
Thank you.
uh-huh.
Now, he was the imminent direct threat, correct?
Yes.
All right.
Use his
Now-
own words against him.
Did you ever think that maybe he was just going to punch you after you punched him?
No.
Oh,
Okay. Now, if I'm understanding this, you're stating that you pulled the firearm out and you had it kind of down?
Yes.
Were you pointing it at him?
No, I didn't have it pointed. It was just pointed down.
It was pointed down,
Yes.
towards the floor.
Yes. When he lunged forward, that's when I stepped back. And there was a reaction
Oh,
as far
like
as like,
this.
the gun just
A
went
hip
off
shot.
as far as when
It
he
just
stepped
went
back,
off,
as he
Pointed
lunged
down.
forward.
If the gun goes off pointed down, how does Mr. Cleereman get one in his eyebrow with only a slightly upward trajectory?
His head, he was like lunging towards me like he was going to spear me or tackle me. And as
So-
I stepped back,
When you step back, did you pull the gun
Still
up?
doesn't work.
okay. Let me draw this out for you here really quick. Okay, so here he is with his little pistol. He's got his little pistola. All right, and here's Mr. Cleereman. He's a little angry, a little frustrated. Okay, a little upset. And he starts coming towards him. And here's Edgecomb, with his fro. All right. Do I have this right so far? I think I'm doing pretty good.
Yeah, it's fine.
All right. So he's saying that Mr. Cleereman lunged towards him like so. Woohoo! Here he comes, lunging at him. Mr. Bobblehead. Woohoo! He's lunging at you like Superman. So tell me, if it's got a slightly upward trajectory on the bullet, means that the bullet, what did he do? Fire it, it bounced somewhere here and then bounced back and hit him because he had a slight upward trajectory.
Right.
I mean, that's the only thing I can think of.
Well, he never made it to geometry class, so he doesn't understand angles and things like that.
Yeah. And that's why he asked that question like he did.
Yeah.
He said, hey, a slightly upward trajectory.
Right.
Which would indicate that he might have been coming towards him, but he is also taller than Edgecomb. So you got two men, one's taller than the other, and you fire with your arm outstretched, it's gonna go to a slightly upward trajectory.
Right.
Which means that there would have been no way for him to be lunging at him.
No.
Yeah. Sorry, guys, for the delay there, but, sometimes you just have to point these idiots out.
Overruled. It's cross.
When you step back, did you pull the gun up?
At that moment, it did go up because I stepped back. It was reactionary.
Just a reaction. So you're stating you didn't mean to shoot him?
There was no intent there. No, I was.
Total accident, he got shot.
Yes, there was
Okay,
no
thank
intent
you.
there.
Thank you very much. Now, if if 4 other people who saw this, say they saw your hand go up and shoot him and he just drops, that's just not what happened.
I don't know if that was a question.
Yep, it is.
Can you repeat it?
If 4 other people see your hand go up with a gun in it and shoot the victim, you're telling us that that's not what happened. Do I have that correct?
Yes, that is
Okay,
correct.
thank you.
There were 4 other people in the stairwell, in the dark stairwell.
Hang on. Ms. Edgecomb, please, there has to be a question in front of you. You don't get to make speeches, please. Go ahead.
Bingo. Yes, there is. Yeah, maybe one is a sword fight. Just whip it out and swing swords.
What happened to the clothes you were wearing that day?
Huh? Well, that's
I'm
a
not
weird
sure,
question.
sir.
Did you
They
get rid of them
probably
like you
were
did the
in
gun?
You throw them out the window?
I changed that day.
Oh, you changed.
Where'd you change?
What?
In the house.
In the house.
In
Your
which
house?
In the house in which I was staying, yes, on Dowsman.
So the video looks like you're still wearing the same clothes, just with a backpack. We remember changing it.
To my recollection, yes.
Prosecutor's just so frustrated with this guy.
One moment, Judge.
I don't know why. I think it's going beautifully.
It is, but he's trying to ask him very specific questions of things that he's testified to.
Right.
And whenever he's testified to one thing and then he asks him a question, he's just asking it a different way. He's answering it completely different. Like,
If police
He changed
had
clothes
never
that night. He didn't
figured
change
out
clothes
you were the
twice.
shooter that day,
right.
would you ever have turned yourself in?
I was making steps to get legal counsel to turn
not
myself
the
in.
question.
So it was always the goal to turn myself in, but I just wasn't sure if anyone would believe the narrative of a
Believe
white
the
man and
narrative?
his wife hunting me down and trying to cause harm to me.
That wasn't my question. My question was this. was if the police had not been told by people associated with your family that you were the shooter that night, were you ever going to turn yourself in?
I
Yes
was
or no?
always gonna, that was, the goal, to turn myself in, but I
So,
just needed legal
if they had
representation.
if they had never identified you as the shooter, your goal was to come in and be like, yep, I'm that unknown person that shot Jason Cleereman. Is that what you're telling us?
With legal representation.
Okay. But only after you got rid of the gun.
Is that a question?
Yeah.
Can you repeat it?
It was only after you were going to get rid of the gun. Isn't that correct?
It was only, that's a statement.
Yeah. Were you, yes, answer the question, sir. You were going to turn yourself in, but only after you got rid of the gun, correct?
No, that's not true. I only did that so that
Thank
it
you very
wouldn't
much,
be
sir.
on my person.
Thank you. Oh, because you didn't want it on your person, right? You didn't want the weapon that killed Jason Cleereman
it's
and
just
could
like-
definitively connect you to this incident to be caught on you. Isn't
That look on his face, like, oh shit, what did I say?
What did I say?
Oh, yeah, didn't want it on my person. Oh, really? And now he is going, oh shit, I said something.
Oops.
Oh, what did I say? What now? Oh, and you can tell that. Hush.
that correct?
I just reacted to protect myself from being harmed.
By getting rid of a weapon.
Wait. I just protected myself from being armed?
Yeah.
That doesn't make any sense.
Yeah.
Nothing else. Thank you.
Judge, I'm gonna need to make a record of a few things and would like a 5-minute break.
Say that again.
Need to place some things on the record. Could ask for a break.
Well, I'm not sure what needs to go on the record. We can potentially discuss that. I'll take a short break for the jury, 10 minutes. Follow my bailiffs out, please.
Oh, getting harmed. Okay.
Yeah.
I thought you said armed.
He
Being armed.
no, he didn't want to get harmed by the popo, because they would have taken down a black man. Had he come into the police station and turned himself in, they would just shout him right there, poo poo poo. Oh, and it's about to go to the next one here. Yeah, the outside of the jury, there's about 8 minutes of. There's about 8 minutes of this, and then there's about another.
Everyone needs to be quiet, please.
There's
The defendant's
about
on the
another
stand, the
18
jury's not
minutes
present, the jury's not in the courtroom.
Of redirect.
There were a couple sidebars. Let's make this brief so we can get the testimony done with this witness. Then I want to discuss scheduling.
That sign
Mr.
was
Ahmad.
crooked.
Figured out. This time,
Is
defense
it
is moving
crooked,
for a
or is it just
mistrial
that
on the
weird
grounds
angle
there was,
illusion?
discussion of his open pending cases. We don't believe that the door was opened to that specifically to mention that as a criminal case. I understand what the state's argument was that he has other attorneys and that they
opened the
potentially
door.
could have assisted him in turning himself in. And I think that should have been where it ended. But then to start talking about the criminal cases, that it's Waukesha,
Did not.
that, there's been some testimony in this case so far that he was also on bail. One of the officers did mention bail.
And see, this is where the attorney's earning his money. He's grasping. And the judge is going to say, no, you opened the door in discussing that he had other criminal cases. All he asked were, did you have attorneys in those criminal cases? Why didn't you reach out to them? You had perfect, easy, accessible legal representation. The fact was that you not only shot this guy, but then you went on the run. You were evading the police.
I think maybe it was alluded to some level here in the testimony. I think given the current circumstances and the climate, all of that would be grounds for a mistrial. So I want to make a record of that at this time.
Mr. Hubner?
I love that. So whenever you pull a piece of pasta, test it and blow on it a bunch to cool it down, but it doesn't seem to cool down, you stick it in your mouth and burn the shite out of your tongue and lip. Oh, I say, but you don't have lips. And there's an easier way to do it. So what you do is you take a small piece of that, shake it off, and you throw it at your counter. You throw it at your cabinet. If it sticks to the cabinet, it's done. If it falls, it's not. It's amazing how that works. And then, of course, you wipe down the cabinet so you don't have to, have that sticky stuff all over it. Whatever hits the floor, you let the puppy.
Exactly.
First of all, Your Honor, the court had already ruled previously during numerous final pretrial motions that the state would be able to bring in the fact that the defendant had 2 court dates that he missed because it went to consciousness of guilt. The fact
That's correct. That ruling was made
Yes.
at multiple pretrial hearings. Yes.
The fact that the defendant had court dates was going to be admissible. That was going to be the intent of really all my questioning until the defendant then decided to make a big deal out of the fact that he remained out of the state trying to get legal representation. My point was, well, he had 2 lawyers. Had he just acknowledged that and that he could have called them and didn't, I would have been done. But the defendant kept acting as though he didn't know who they were or that he had lawyers, and then even went so far as to say he didn't even think they were criminal defense lawyers. I would note that every single one of the steps along the way that the state took was only after the court in chambers told the state they could. In fact, the court, quite frankly, I think I could have even gone further. I didn't mention the charges. I didn't mention whether or not they were felony or misdemeanor. I didn't mention that there was a gun in one of them and that the other was domestic violence. I stayed away from all of those. I tried to get through that portion of it as quickly as I could. And I just couldn't, based on the sheer evasiveness of the defendant's answers.
Yes.
Let me step in. The defendant testified repeatedly, and I'll leave the assessment of his veracity to the jury, but he testified repeatedly, at least the state would argue, feigning ignorance of having other matters pending or proceeding. Then he, on more than one occasion, again, maybe accurately, maybe he was feigning ignorance, he, knowing that he had attorneys on those matters, said, well, I didn't know that they were criminal matters. We discussed it off the record, and as I said, on the record in less than a sentence, yes, I believe then and still believe that the defendant opened the door to additional examination. Arguably, again, the determination of veracity will be part of the calculation and reviewing the evidence, the testimony, the witnesses for the jury, but arguably the defendant was clearly lying and or feigning ignorance. As the state noted, I think the state could have potentially went further. They didn't. It's probably fine that the state did not go any further. But as part of my analysis, the defendant sat on the stand and said repeatedly, effectively, I don't have an attorney. I didn't know I had attorneys. And then even went as far as to say he didn't know he had criminal defense attorneys. As I said off the record, that's hard to believe when someone had at the time a pending misdemeanor with 6 counts that involved allegedly a weapon.
6 counts.
And he had a separate domestic violence case, one of them at a misdemeanor level, but with 5 or 6 counts, based on what the state's told me. The second one, a felony level case. For the defendant to continue to at least potentially evade or feign ignorance on that, he opened the door to expanded examination by the state. It was valid, it was legitimate, the motion for mistrial is denied. Now, I'd like to discuss scheduling. Gentlemen, I've been telling both sides for the last 2 days, it may have actually started on Friday, that we need to move things along.
Yeah.
I told the jury last week we'd be done by Monday. It became apparent probably last Thursday or Friday morning that Monday was not a reasonable goal. But here we sit at 2:50 on Tuesday. So we need to move the case along. I have encouraged both sides to move it along multiple times. I've not cut off questioning, at least not in the broad scope of questioning. But the jury will come back in, we'll conclude with this witness. Is this the defense's last witness or not?
There's just Dr. John Black, which should be concluded today.
And is the state planning any rebuttal? I guess I don't need a final answer now, but I'd like some inclination, please.
I'm inclined to, but it wouldn't be long even if we did.
Would not be long, is that what you said?
Yeah, Your Honor, it's the only rebuttal
Can you
testimony.
use the mic again, please?
Yeah, I'm sorry, I keep moving that thing. Judge, the only potential rebuttal testimony that I might have would be 2 to 3 opinion witnesses. They're simply the character witnesses that I previously noticed. Since it's opinion testimony, there's really not too much I can get into other than their opinion as to the victim, whether or not, he would say certain things. It would be fairly quickly, I think, if I did it. And I can't see more than 5-10 minutes of witness. So we've got 3 of them. They're already here. They're already lined up.
All right, bringing the jury in, the defense can do redirect, then the state can do recross, then I'll send the jury out. The defendant can obviously be off the stand and back at counsel table. Then I'll expect the defense's last witness. I expect to be done with at least that testimony, the defense case, by the end of the day. That's 2 hours. That should be plenty of time. Let's proceed. I'll have the jury brought in.
Yeah, and they are going to bring the jury back in, and then they're going to do a redirect on this, which is going to be freaking 18 minutes.
The gallery can please, again, be seated and silent, please.
Like I said, I may get through all of this tonight. It's a very big possibility. And then I'll be done with Edgecomb. It'll be so awesome.
They have witnesses though.
Yeah, but it's not going to take
All right,
very
jury's
long
back.
on
Go ahead, counsel.
Mr. Edgecomb, are you nervous at this point?
Very.
Can you speak up, please?
Yes, very.
In the mic, okay. And why are you nervous right now?
Because the white man's out to get me.
Due to the circumstances at hand, like my whole life is, pretty much on the line right now.
And did you give any concern to the life of the man that you just deleted and then ran away from? Any concern? None? No remorse?
No.
See.
Now, Mr. Edgecomb, have you ever been, questioned, in a proceeding, in a trial before?
No.
Oh, really?
So this is new to you?
Yes.
Oh, boy.
Mr. Edgecomb, do you recall ever being diagnosed with
How is that
ADD?
possible?
Yes, as a child.
And can you explain to
Because here's the thing. Have you ever been questioned in a trial before? No, never been questioned in a trial. No, because you didn't show up to them.
Oh,
You had 3 trials back to back to back to back to back to back to back.
gotcha.
But these are only ones that they're bringing up. These particular cases that are currently happening. And so he's never gone to trial for any of them? And they're opening the door for it. They just open the door for them to ask even more questions on this. Oh,
the members of the jury, how you kind of prepare yourself as far as, answering questions and kind of dealing with, matters so that you're
I
somewhat
have you
comfortable?
tell me what to say.
I pray a lot.
Right?
And yeah, mostly just through prayer. And
Here's an idea. Take your prayers, place them in one hand, take a dump in the other, and see which one fills up faster. Just curious, you tell me, Edgecomb.
trust in God.
Now, does Attorney Huebner make you nervous at all as far as the way in which you were questioned previously?
More than nervous.
Objection, Your Honor, relevance.
All right. Now,
Yeah. Welcome back, T-Rex. Glad you could make it, man.
now, Mr. Edgecomb,
Hey, T-Rex.
how do you feel when the word homicide is used, when you're asked a question regarding involvement in a
At some point, I would start objecting. Like, objection, Your Honor, on redirect, what does this have to do with anything? I mean, we're talking about a guy's feelings here. We're not presenting facts of the case. His feelings. And how much are we going to tolerate of his shenanigans is basically what is going to happen. I can feel it coming. Oh, crap. Thanks for the wrench. Well, no problem, man.
homicide? How do you feel about that
Objection,
question?
Your Honor, is to the relevance as to his feelings over the word homicide.
All right, his feelings as to the term is not relevant. Sustained.
Is there any way a question is asked of you that makes you feel a
Objection,
certain
Your
way
Honor.
about what occurred on September 22nd of 2020?
Objection, Your Honor,
Yes.
as to his feelings due to questions. I don't see how that's relevant.
Saying it's not relevant. His feelings are not relevant about direct or cross-examination. Let's move on. The last answer stricken.
Mr. Edgecomb, you were asked on cross-examination about why didn't you go to a police station? You recall that?
Yes.
Can you explain your state of mind after, using what you call, self-defense against Mr. Cleereman and going down the stairs? What was on your mind at that particular time?
Objection to relevance of state of mind doesn't matter. That was not what was asked on direct. And if he would have been smart, he would have came back and he would have said, he would have been asking him questions that were more directly involved in this case and not his state of mind. Oh,
Yeah,
I
his
was running
state
for my
of
life
mind is a
because I was so
mystery.
scared. Yes. It's like this this mystery that everyone uses, that word affordable housing. What is affordable?
Right.
What's affordable for me might
Subjective.
not be affordable for you.
I was in shock. I couldn't believe what had just taken place.
Yeah, you shot a guy in the
Now-
head.
You were asked as far as
Uh-oh.
your route going home. Were you thinking about being efficient as far as saving time at the time that you left the scene on September 22nd
The
of
time you were
2020?
running like a little bit.
No, I wasn't really thinking like in those aspects.
thinking,
I
no.
was just in shock. I really wasn't. I was still trying to get away from, the whole situation.
Trying to get away.
Now,
Well,
you indicated on direct that you had fear, and one of those fears were because you killed a white man. Is that right?
In front of
Yes.
this black wife.
And how does that relate to your, if you will, your eagerness to go to a police station after
Objection,
such
Your
an
Honor.
occurrence?
That's like it's like one of the last, like at that moment, it's like, it wasn't on my mind because I was in
Because
fear
you're a
of,
fucking
even the
criminal.
police, even if they
Sorry.
would believe, what had occurred.
Jesus. That you shot a guy?
And did that fear of going to the police remain for the entirety of almost 6 months?
Yes,
6 months he was on the run.
it did. So even upon, being, when the
Yep.
when the Kentucky trooper pulled me over, like I was even in fear then. They had me on the side of the road by a ditch. They wouldn't even let me stand in front of their cameras. I had in front of their vehicles where they had a dash cam. I had my hands up the whole time, and all 4 officers were like, "Hey, you can put your hands down," but I was in fear of what they might do, and then in the situation, and just figuring out the dynamics
The
of
best
the
lie that you
situation
can
that
use.
had occurred on September 22nd, if they were to figure that out. And I didn't want to go into their custody involuntarily. No one knew where I was, and there was no guarantee like I would make it back, even in their custody safely.
At any point in time,
Now,
you could turn yourself in,
Mr.
right?
Edgecomb, on cross, the state brought up 2 other lawyers that you had regarding other matters, correct?
Don't do
Yes.
this.
Now, you testified on direct examination that between you calling and Ruby Mazzell calling, that you were quoted a certain amount of money to retain a lawyer, correct?
Yes.
What was that amount again?
They were in ranges from $50,000 to $140,000.
All right. And did you have $50,000 to $140,000 at the time?
No, I
Is that the
just
reason
shot
why
a
you
man
had
on the run.
your family set up a GoFundMe on your behalf?
Yes.
That's right, Roxanne.
Now,
Mm-hmm.
let's in the cases that the state brought up, were those attorneys assigned to you
Yes.
by the court?
They were public defenders. So public defenders.
Okay. So you didn't pay any money when you received a public defender, correct?
No.
What, you got something against public
Mr. Edgecomb,
defenders?
is there, in your mind, is there a distinction from a public defender and, let's say, a local criminal defense attorney?
Yes.
Can you explain to the members of the jury how you perceive the difference between a public defender and a local criminal defense attorney?
So, do you know the difference between a public defender and a local attorney?
Well, one you don't have to pay for if you qualify.
Yeah. But what other differences would they have?
Not much.
They probably have a larger caseload.
Well, that's true. That is true.
You know, and so I'll say this for all you assholes that are wanting to use this as some sort of defense. They do have a much larger caseload. More
That's
than
true.
likely, it's about 10 times the amount that a normal person will have, because of idiots like Edgecomb that are like hard-ass criminals that will do the most vile things if given the opportunity and unsupervised. So they do have a large caseload. But they have an advantage over just some private individual defender, is that they've tried thousands, if not hundreds of thousands of these cases. And they will fight for their client as vigorously as if they were getting paid $1 million to do it, because that is their job. And they probably know the ins and outs and things that can and cannot be filed properly and appropriately to expedite good judicial representation. So if you want to get all pissy about public defenders, just realize those public defenders are there. They are practicing attorneys, and they're probably a little bit smarter than just your average run-of-the-mill defense attorney, ambulance chaser. Just saying. Don't discount them. Not saying all of them are, but don't discount them.
As far as a public defender, they don't fight as hard for you, especially being a black person. Like, they don't put in efficient work ethic to help you as far as in matters that are being handled in courts. They tend to not even know who you are upon seeing them. And even going to court, they got to figure out who you are and what your case is. Whereas what I've known, like, if you're paying for a lawyer, they would know who you are and they would help you efficiently and with great ethic in your matters that were at hand. And also too, I was in the understanding that different matters require different lawyers. So in these matters, and in the matters that were discussed previously, and in these matters that we're dealing with today, I thought it's different, degrees and matters that they handle as far as, from like a public defender or like a paid attorney.
Well, and here's the thing. This is a misconception that you've got, but I guarantee you a public defender would have done a much better job for you than your current attorney that you paid a hell of a lot of money to, or your family paid a hell of a lot of money to come and defend you, because he's a race grifter. And that's all. He doesn't give two shits about you, bro. All he cares about is that paycheck. He doesn't care about your family. He doesn't care about you. He is a race grifter. You got suckered. Should have gone with a public defender. Probably would have lasted much longer. Or at least they could have worked out a deal with you that might have gotten you a little bit of time off.
Yeah.
You wouldn't have had to go through this whole trial and rack up a whole bunch of money, because they probably would have worked a deal before it ever went to trial.
Now, Mr. Edgecomb, the state, they asked a question of you on cross, and they indicated that you said that I can't let them get away, and then you punched them, correct?
Yes.
All right. Now, Mr. Edgecomb, you stated that you were a bit infuriated at that time, correct?
Yeah.
Yes.
Mr. Edgecomb, did you have the firearm on your person at that time that you punched Mr. Cleereman?
Yes.
Yes.
Well, you had a firearm with 17 shots in it, correct? This is what you testified on direct, right?
Yes.
Why didn't you fire
Why
more?
did you not shoot Mr. Cleereman instead of punching him at that particular moment?
I never intended to hurt or harm anyone. That
But
was
you
never
punched
the
him.
goal of mine, as far as, even, killing or shooting, anything of that matter.
No, you just wanted
So-
him to acknowledge you.
And is it true that the only reason why you put the trigger is because of self-defense at a time that Mr. Cleereman
No, it
lunged
just
towards you
went
with
off.
what you
That's what
believe
he
to be an object in
testified
his hand?
to. It just went off.
it was reactionary to him lunging towards me. Yes, the gun just went off. I didn't even, put any thought as to, the gun going off. It wasn't like intended. It was reactionary.
Yeah, he carried.
So it was reactionary based off a threat that you perceived at that moment, correct?
Yes, being told I'm gonna kill you.
You forgot a word.
And did those words, "I'm going to kill you," cause you to believe that you needed to defend yourself at that time?
Yes.
Mm-hmm.
1 second, please.
Yeah, you might want to need a couple of those. Just so annoying. Yeah, ask him about his fear. Like, we need to drive home the fear. You guys are attorneys.
Now, Mr. Edgecomb, you keep indicating that you needed to protect yourself against Mr. Cleereman at a very specific time, correct?
Yes.
And can you explain to the members of the jury all those factors that went into your mind at that particular time that you needed to, pull out the weapon, aim it at Mr. Cleereman at a specific time, and, respond as you recall, a reflex or whatever you describe it as, but pulling the trigger at that time? What are those factors?
Me telling him to stop, just to, hey, like, stop, don't come any closer, to see
That's
if
not
he
what
would,
you said.
just be deterred from, even wanting, pursuing me. Yes, even the threats that were behind him.
There he goes, licking his
you
lips.
repeat that
Got the
question
snake
to me?
tongue. Lies.
Can you repeat it again so I can make it sound better?
Well, honestly, I kind of got it myself. But basically, it's just going into the factor that you realize at that very specific.
Wow.
He forgot it himself.
Sounds like it.
Because,
Reps
I was just opening the door for you to say something because you're smarter than me. I don't know what the hell, dude.
We probably
moment, the
did
threats
want him
that
to
you
say the same
realized.
thing again.
I just the pain.
At the time, you felt the need to defend yourself.
Yes, the threats behind him being direct in front of me, imminent threat, and him even startling me.
Okay. Now, Mr. Edgecomb, have you ever had any experience as it relates to weapons training before?
Objection, Your Honor.
And can you
to
explain to the
relevance.
members of the jury what was the training that you received?
In CCW training courses, and also too being working formally in security.
Now, is it, you keep using this term, imminent threat. Is that where you learned that word from? Is that training that you received?
Yes.
Now, can you explain a little bit about the security work that you've done prior in life?
Yes, it was
Objection,
working. I
Your
worked
Honor.
side by side with
How is
Border
this-
Patrol
how
and
is
Coast
this
Guard
worker
doing maritime
redirect?
security on various docks. And also too with Allied Barton here at the train station, and also too in Florida.
This is not good.
One second.
So he's gonna go set this stuff back down there. He has nothing left to say. Here, make it look like I'm smart or something. Say something witty. I can't read my own handwriting.
Now, just for the jurors' edification, if you could explain what is an imminent
Edification.
threat to you,
Edification.
Mr. Edgecomb?
Direct person, like close to you, in close proximity of your person, almost invading like your personal space. Imminent, direct, clear.
And
Your
Mr. Edgecomb, can you
President-
explain any
President
emotions
Danger.
or bodily responses that you had to the threat that you perceived on September 22nd?
Yes, I was in fear, like borderline shaking because of, just previously about to get hit. Well, getting hit, and then also too being about to directly get hit, and in which I, ran from and was able to get away from them, directly trying to hit me, deliberately trying to hit me.
And did you have any other bodily
tongue.
experiences that you noticed as a result of that threat?
I'm almost starting to get used to it
Just
now.
fear and
It's
shaking,
scary.
like, you know.
Yeah.
and
Okay. All right, no more questions for you.
Fine, state.
How can I word this?
Somebody kill me.
Because
Weapons training?
Yes.
They teach you how to shoot?
No.
Did you have a weapon during this weapons training?
Yes. They don't.
you had weapons training, but they didn't teach you how to shoot.
Were you using water guns? What were they using?
I don't know. I'm so confused. Wait. If you had weapons training, then they taught you how to shoot.
No. Yes.
No?
No. Yes. No.
No. Yes.
Like in the training classes, they don't like, we don't shoot in the class, we go to like a firing range.
So you've been to a firing range to shoot, right?
Yes,
And you realized, and you've been trained on how to hit your target, right?
No. Can you
yes.
repeat the question?
No, thank you.
We don't
All right, I'm
shoot
saying
in
the jury, we're
class.
done with this witness. I think we're gonna have one additional witness. Please take a break, 5 minutes, 10 minutes, then we'll be back with what I
Ding-dong.
expect to be the last witness. You can step out. Everybody else in the gallery, remain seated and silent, please.
I mean, it's just, it amazes me, the stupidity of this guy. Just, he's trying to get one over and he doesn't realize. He does not realize how crappy it makes him sound.
Mm-hmm.
Let me see. What do we got? What do we got? Anything? Yeah, I'm looking to see if what the last one was. Yeah, he's not anything. Give me a second. All right. So the last guy was a nothing burger. He basically was up there just going, well, he could have been thinking or running because he was so scared and so horrible. And, he had this belief of fear and basically gets destroyed on cross. And it's not even, it's 25 minutes of your life that you'll never get back again. I watched it in about 30 seconds. It is not worth showing. But these Borowski moments are glorious.
We can discuss jury instructions. The plan will be this. We're going to discuss jury instructions. The state has drafted the instructions. I'm going to excuse the jury. I will tell them to be back tomorrow at 9. If there's any last minute things, we can deal with them between 8:30 and 9 tomorrow. I will read the closing instructions tomorrow after we agree on them. I think the state suggested 1 hour. The defense asked for an hour and a half. I will grant the defense request that was made off the record. Each side can have up to an hour and a half for closings, but that's a hard stop. And both sides should remember that sometimes less is more. Don't feel obligated to use every minute of the hour and a half. But I will tell the jury, be back at 9 o'clock and ready to go. We can discuss jury instructions outside their presence. I will excuse them. I will obviously have all 13 come back tomorrow, though one of them will, of course, be excused. That's
Hey,
how we'll
Betsy,
proceed. I'll bring them
I didn't
in.
even
I'll
see
excuse
you
them with
slide
the
in
regular
there.
instructions at the end of the
You're
day.
so
I'll tell them to be back at
smooth.
9 tomorrow for closing instructions and closings. You can bring them in, Deputy, please.
So
We'll start promptly at 9 o'clock.
he's just given jury instructions. Don't need to give that one. And this is the jury charged. Court and counsel.
Versus Theodore Edgecomb, 20 CF 3535. Appearances.
Grant you before the state.
Warren Hunter, Nico on behalf of Theodore Edgecomb.
Yager Lamar, on behalf of Theodore Edgecomb.
Mr. Goodner, so it doesn't get ugly as we argue, grab the microphone, use it, please.
Oh, sorry, I put it up on the, I'm trying to be proactive, I apologize.
All right, it's just after 9 o'clock, the jury's back. There's possibly one or two things to discuss, then I'm going to instruct the jury. Both sides will make closing arguments. I think the state suggested an hour, the defense suggested an hour and a half. I'll allow up to an hour and a half maximum. That's a hard stop at an hour and a half. Again, both sides hopefully are aware that you don't necessarily have to use the hour and a half, and sometimes, if not most times, not spending too long on a closing is advisable. We discussed yesterday the instructions that the state submitted. I don't know if either side has anything to add on that. I believe it was the defense that drafted a proposed additional instruction. Is that correct?
That's correct, Your Honor. I made some additional edits after speaking with Attorney Huebner. I'm about to email our final draft of that to the court and to Attorney Huebner. I don't believe there's an objection on it.
Well, I guess I need to see the final draft, but Mr. Huebner?
Your Honor, I don't necessarily have an objection to it. I just raised the concern that the defense counsel's version had the court explicitly telling the jury about the tragedy in Waukesha, which I thought was potentially...
Is no way going to happen. I don't need argument from either side. No way on God's earth am I going to allow a sentence that says, finally, evidence was received that the defendant was on bail at the time of the charged offense. Any recent events in the neighboring county of Waukesha shall not affect your deliberations in any way, and you are to decide this case solely based on the law and facts presented to you during the trial.
You believe they tried to slip that in there?
Wow.
And he was like, no, we're not discussing what on Waukesha. That has no relevance here whatsoever. Even a mention of it taints the jury. But that's what they wanted to get in. That's B. Ivory Lamar trying to slide that in.
Mentioning that situation in Waukesha, I presume, obviously, that's a reference to the Brooks case. Arguably one of the biggest tragedies and worst crimes this city, or I should say state, has seen in the last decade. I mean, no way. It's hyperbole. It's inflammatory. It has nothing to do with this case. It would potentially distract the jury. Not a chance. So as long as that's out, let's get me the revised version, please.
And Attorney Huebner.
And as far as the special instruction, the second paragraph that's proposed and the third paragraph, I don't particularly have a problem with. I think they accurately portray the situation and accurately state the law. I want to hear the state's position on the first paragraph. The first paragraph reads, evidence was received in this case that the defendant had other open cases at the time the offense was committed. You are not to allow this fact to affect your deliberations on the defendant's guilt or innocence as to the charged offense in any way. The state want to comment on that? You know, my concern is the defendant discussed some of those open cases because, as I said yesterday, he clearly opened the door. I think the defendant feigned ignorance on his multiple criminal cases. The parameters were drawn multiple times by this court in pretrial motions and in conversations off the record. And the defendant on multiple occasions, I think, feigned ignorance or was making a speech to the jury saying he knows nothing about the fact that he had two criminal cases with two separate criminal defense attorneys. So it goes to veracity. So saying that that's not a factor, I don't know.
Maybe, Your Honor, then the best way to do it is to leave the first sentence as is, and the second sentence should just state that evidence was received only as it applies to the defendant's credibility, and it should not be used for any other purpose.
I think that's better. It's a credibility determination, Mr. Ahmad. Your client put that in issue. His credibility was put in issue by his repeated denials and repeated conflicting testimony. It is an issue. It affects his credibility. So if you want to modify that sentence, fine. I want the jury in here. I want to instruct them. I want closings done. Say that again, Mr. Huebner, please.
That evidence was allowed only as it pertains to the defendant's credibility, and it should not be used for any other purpose.
I think with that modification and the other modification to the last line, it's acceptable, and I'll give the instruction being requested by the defense with those two modifications.
Damn. Just quick. He is so
A couple of
quick.
other issues, Judge, for closing instructions.
I will brief.
Number one, we are requesting, based on the case law, an instruction for negligent homicide. That's under 1175, homicide by negligent handling of a dangerous weapon. The testimony or the basis for that is during cross-examination, I believe, there was some clarification questions asked by Attorney Huebner about how the gun had just gone off, and then...
Counsel, I apologize for interrupting. Then arguably, we take self-defense off the table, and I won't instruct on self-defense.
So, Judge,
Then it's just an up or down, guilty or not guilty on the counts.
Yeah.
Because your client, I mean, arguably, as I thought about the testimony yesterday, there were statements made by your client that could lead a jury to at least consider and possibly believe the self-defense claim. But as you know, he repeatedly insisted on direct and cross that yes, the gun just went off, acting like it was somehow an accident. So I'll hear from both sides, but I don't see how negligent
You can't have it both ways.
homicide fits.
Yeah, you can't have it both ways. Like, we'll be fine to call it negligent homicide because you're saying, oh, the firearm just went off. But this self-defense, it has to be kicked out of there. If that's
Right.
what you
That
want.
goes off the table. Right.
Yeah. Which makes complete sense. I mean, you know, you're claiming, oh, it just went off. Well,
Right.
if it just went off, then it wasn't self-defense. Or if you're saying that it was self-defense, then you're going to have to disregard anything he said about it just going off.
Well, yeah. I mean, his whole testimony was his fear for his life. It's not an accidental discharge.
Might have been with the tonsil twins.
With self-defense. In fact, Mr. Hubner?
Well, I think Mr. Ahmad wants to finish his argument, and then I'll respond, Judge, if that's okay.
Okay, go ahead.
Good
Judge
choice.
Stacey Carroll Watkins, 244, Wisconsin 2nd, 205. It's a 2002 Wisconsin Supreme Court case. It was a review of a decision of the Court of Appeals, and basically the Wisconsin Supreme Court said those two concepts are not mutually exclusive, which is specifically self-defense and then negligent homicide. If there was some facts in that case where the court found that there was a basis for both, and that's just an issue for the trier of fact. That was a court trial in the original case, but essentially it's no different. It's a jury question as to how they want to resolve all of these charges. They're already going to be receiving the lesser includeds, so they're going to have already 4 different homicide degrees to consider. There is some evidence under the some evidence standard also if they decide to resolve the case for an accident, according to the defendant's testimony, which is testimony that was developed further by the state, then I think that's also been put into issue. I think the state's argument, Judge, is going to be that, well, in the Watkins case, there was first some assertion of the threat of force, and followed by then an accident occurring, perhaps, from a struggle between the parties. In this case, the facts that would support that would be there was some testimony about Mr. Edgecomb telling Mr. Cleereman to stop, and then he approached, and then Mr. Cleereman had his fists up, and we saw the video, and we've seen that many, many times in this case. There was a lunge, and then there was a very quick discharge of the weapon. I think there was some evidence that there was a showing of the threat of force, and obviously it's not the same exact case, but there is a basis to have the jury also look at that charge and consider it in deliberations.
First of all, Your Honor, I don't believe if you are to go to accept what defense counsel is stating regarding the Supreme Court case, it's not the same. In that case, what happened was the individual pointed the firearm in a deliberate show of force. This defendant, according to what the defendant all of a sudden came up with at the 11th hour, was that he didn't. He says stop, but he never shows the gun. He never points the gun. He supposedly has it down at his side. And then he doesn't even necessarily say, defense counsel, I think, was trying to get him to say that he aimed it. Never necessarily even said that. He says he backs up and it goes off as the victim is supposedly lunging or trying to spear him to get the gun. I also do not agree that the video shows a lunge. The video shows the victim literally collapsing.
I did not see a lunge on any of the videos that were played multiple times. I did not see anything that was close to a lunge. The jury's the finder of fact, but I did not see a lunge.
I mean, it's up to the jury. But based on these facts, Judge, in that case, they're not mutually exclusive. In this case, they are. There is not a situation in which what the defendant testified to is consistent or even comes remotely close to the intentional use of force or even show of force. According to him, he didn't do anything. So they are mutually exclusive, even under the case that defense counsel cites. So self-defense would not apply if you have this negligent homicide. I would just also note that in order for a jury to acquit on second-degree reckless, which is they'd have to get all...
Well, no. He pulled out the gun, intent to use, no self-defense. No, that's not true. That's not true. No, and because, you know, just brandishing a weapon, he's not exposing it to anybody. would say that he's waiting to assess the situation. All right. At the point where the guy lunges at him, and we'll just use his words, at the point that the guy lunges at him is the point where he would have stepped back, took the shot, and dropped him immediately. If he would have said yes to all of those things, he lunged at me, I fired, and I hit my target, and he died. And I stayed there, waiting for the police to show up so I could show that, you know, this guy attacked me. I didn't attack him. The punch happened over there. We're over here now. He would have had a much better chance of using a self-defense. But the fact is it wasn't self-defense.
Well, and that was a big part of the Rittenhouse case too. You know, they were trying to say because he had the gun out, he was provoking.
Nope, it's
And
not.
That's not how it's ruled, right?
Same way with him, it's not provoking. You're standing back, you're assessing the situation, you're going, stop, don't come any closer. At the point that the guy lunges at you and you shoot him, you've used deadly force. Whether you kill him or not, doesn't matter. That right there at that point would be self-defense. You can't use the defense of saying, I don't know, the gun just went off. Then that's negligent homicide. You were negligent in your actions that led to somebody's death. Even if it was self-defense, it still can be negligent homicide because your intent wasn't to kill them. Your intent wasn't to stop them. You know, negligent homicide would be you fire the weapon because you're scared, you're shaking in your boots, you fire the weapon, it goes off, it ricochets off the ground, hits him in the eye, and as a result, 3 people die. That would be negligence. That would be because you did something really stupid, or you're driving by and you're just spraying bullets into a crowd. That would be negligence. That's because of your own negligence, your own stupidity, that they're no longer alive. Yeah, you can't claim self-defense in that situation. It was because of your stupid actions that somebody died. So one or the other. That's all they're giving them. Yeah, intent to use is self-defense. That it can be self-defense. Like the guy that came out threatened another guy that, hey, you need to step off my property. You're on my porch. Dude grabs his firearm in an attempt to take it away from him. And in the process, he gets shot. Self-defense. Although the firearm went off, he came out there with clear intent. Big difference. Big difference.
All the way down to second-degree reckless. No utter disregard for human life, no intent. They get down to second-degree reckless. In order to get from second-degree reckless to homicide by negligent use of a dangerous weapon, the only difference between those two is reckless requires, and just so we have it 100%, that the defendant in that situation was aware that his conduct created unreasonable and substantial risk of death or great bodily harm.
Right.
In negligent, it's just that he should have been aware. Well, he admits to having weapons training. He admits to knowing that there's going to, about the weapons.
Again, please.
Sure, Your Honor. I pulled up let me just pull up the actual jury instruction that separates the two of them, because if we're looking at this, the difference between criminal reckless and criminal negligence. This is from the jury instructions. Both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal reckless requires that the person engaging in the conduct be aware of that risk, while criminal negligence requires that the person engaging in that conduct should have been aware of that risk. In this case, I don't think there's anything that puts that portion of it at play.
as to the difference of whether or not the defendant did or should have known. He said he has weapons training, and I don't necessarily know that's in play. I would just note, if defense counsel is going to do this, the least thing they could have done is draft it for us.
Yeah.
If the court wants to add it, I'm working on it now.
I agree with the state. I don't think under that case, I don't think it's the same. I don't think it applies. I don't think it applies based on the facts and the testimony. The state makes a salient point somewhere out of nowhere on redirect to defense questioning. Somehow, I think it was a surprise to everyone, the defendant says he has weapons training.
Yeah.
That's a very salient point. I'm not giving negligence. If
Oh.
the defense has given or modified that last sentence or two on the special instruction, email it to my clerk, e-file the final version. I guess you can e-file the other versions just for the record. But then I want to bring the jury in and give them the instructions, which will take a bit, and proceed to closings.
Yeah. He
Could the
burned
defense
himself.
modify that special instruction, please?
Yeah, I did, Your Honor, and I did e-file that and submit that.
He burned himself on the stand. Edgecomb destroyed himself. They took negligence off of the table. Like, the jury can't even consider negligence because of his screw up. Because of him saying, yeah, we had firearms training. Well, I mean, we never fired the gun in the classroom. Like, did you go to a firing range? Were you trained on proper use of it? Then you knew what this was going to happen. This isn't like some, 5-year-old kid that finds mommy and daddy's gun and, shoots
Right.
the sibling. That would be negligence. No, he was well aware of what that firearm could do, and he even had training in it.
Right.
Oh,
All right, hang on a second. All right, 2-minute recess. My clerk's printing.
Under the theory that the defense is trying to get it in this situation, I'm willing to allow the negligent, although self-defense wouldn't apply to it under the theory that the defense is trying to get it in this situation. So it has been modified that way. Then after I did that,
Use the mic. So can I characterize it as reluctantly stipulating to the instruction on negligent homicide?
yeah.
Fine, because as I said off the record, I was not going to give it. I think the decision in Watkins, which I glanced at yesterday and had a bit more time to review while we were off the record, is a different situation. But if the state's stipulating, fine, I'll give the instruction on negligent homicide.
Oh,
now, I
wow.
think we've reached the point where literally the jury can consider every form of homicide that exists in the Wisconsin statutes, correct?
Take
He
it all
does-
into consideration.
He does not look happy about this because he basically instructed him take negligence off the table, and the state's just like, no, we'll leave negligence in there because, I mean, I think he really feels bad for Edgecomb. I really do. I think that he feels bad for Edgecomb because he's not the brightest guy, and he's got the worst freaking attorneys that he could possibly get, and he's not out to burn this guy.
Right.
He just wants to make sure that there is some justice for somebody that lost their life. And you have to take that in consideration. That's what this is all about. Someone lost their life over stupid shit. And, it's like, I don't want to see this guy spend the rest of his life in prison.
Well, no. You don't want to, but you also don't want him out on the streets either.
Not right now, not until he can get his shit under control. And you hope that there's going to be some sort of reformation in jail.
Am I missing one?
felony murder, you're missing felony murder. I'm not asking for felony murder. So
Well, please don't, because we've already given 5 of the 6 possible homicide instructions that exist in Wisconsin. I'd like to not set the world record for lengthy jury instructions. Mr. Ahmad, I hope we're done discussing this. Is there another issue?
The last issue, placing on the record, states objecting. But
Oh,
I think if we're doing the next.
It's just like, I'm giving you so much. You
Right.
see him just sitting there going, dude, you're pushing the judge, and I'm trying to help you out so we can move this thing on. And you are pushing this judge to his limit. You can just see the frustration. It's like, I need more Diet Cokes.
Negligent,
Yeah.
then the accident 772 should be given. I know this, the accident 772 instruction should be given based on what was elicited in cross. That's, I know the state's objecting to that.
Mr. Hubner?
Your Honor, accident is him trying to state, the defendant trying to allege that he did not have the mental state in order to commit the negligent. If their whole point is that it was criminal negligence.
I'm not clear what the point is at this point. Maybe it'll be illuminating to listen to the closings, and the jury is the ultimate arbiter. The jury will consider the evidence. The jury will render a verdict. But I'm extremely confused by the point the defense has been trying to make. They tried to make one point for an entire 6 or 7 days. Then their client took the stand and basically changed what was being implied, if not directly argued to the jury. Mr. Edgecomb did everything he could yesterday to say the gun just went off. So I'm not clear what point the defense is making. Maybe we'll find out at the closings.
It applies with this fact pattern. It applied in that other, in the case the defense is referring to. It doesn't apply to this. The defendant is
He's
not
so
disavowing
pissed
the mental
right
state.
now.
In fact, he's in fact stating he had the mental state, especially based on his weapons training. So therefore, sorry, I'm trying to get.
I don't blame the state. By the way, gentlemen, we discussed a lot of this yesterday. We spent 45 minutes on instructions yesterday. It's frustrating when the defense adds all these additional requests on the morning I'm going to instruct the jury. I told the jury to be here between 8:45 and 9. They were all.
Oh, I'm so sorry to hear that your son was hit by a car. Oh, hit by a car a couple of weeks ago.
awful.
He's doing okay. I'm so sorry to hear that, Betsy. Oh, man. So 2 fractures in the left arm, cracked ribs. It's now the lawyers and doctors' hands.
So sorry.
Yeah. Man.
all here by 8:45. It is now 10 o'clock. It benefits no one, and it is not fair to a jury to have them sit in the jury room hour upon hour.
Because of your bullshit at the
Instruction 772.
13th hour.
Accident does not apply, and I'm not giving it. That request is denied. So,
And that's why Mr. Hubner is sitting there going, we're like, I'm trying to help you guys out here.
give me a minute, as we've now done, I think, 4 separate versions or 3 or 4 versions of the instructions. Hang on. All right, having the jury brought in. Everybody can.
All right. So we've got the prosecution's closing, which is 23 minutes. We're about 2 hours, and so yeah, we're good. So how you doing? How you feeling?
I'm doing okay.
Okay, not stressing you out. You're doing okay.
No, you're not stressing me out.
Okay, all right.
No.
Well, just checking on my co-host here, making sure that she's fine, and
No,
you know,
doing good.
if she has the need to get naked, Bad Duck is watching. Just so you know.
Start and proceed with the closing from the state. Mr. Hubner.
Awesome! Congratulations.
Can everyone hear me? Okay, good. I see that. Ladies and gentlemen, first of all, I want to thank you for your time and your patience. This has taken longer than what you were told it would. You've listened to over 20 witnesses. You've heard over 100 exhibits. You've watched a video. You've seen me drink about 30 Diet Cokes. You've been here for a long time. And you've been patient. We're here about something that almost boggles the mind on how tragic what happened is. On September 22nd of 2020, 2 different men were heading out. The victim was with his wife. They went to a bar, they went to the happy hour, and then, because he'd been drinking, he asked his wife to drive. They decide, because it's a nice night, to drive down Brady, and he has his window open. Now, ladies and gentlemen, as you've heard, the defendant, well, he left home. And he left home with that firearm he wasn't supposed to have. He left with that firearm, and he's on his bike. And he's walking originally.
Now, ladies and gentlemen, there is an incident that occurs. Ms. Cleereman testified and told you about
That's
how,
jury
out of nowhere,
instructions.
in between two cars on the north side of the street, the defendant just kind of juts out.
Hey, did you miss the full retardation? Yes, you did.
Yes. Yes.
Yes, you'll have to go back and watch it now. Because it was full retardation, how fast they destroyed him. Now, this is the closing arguments. We're getting down. Damn, you'll have to go back. Yes, this right now is the closing arguments. And it is 23 minutes long. It is so fast. I even have it on 1.25 speed, so it'll probably go even faster than those 23 minutes if I don't pause it, which I'll probably pause it anyway. So it'll probably hit about 23 minutes. But the full retardation comes on the closing arguments on defense side. Who told you to repeat that answer? Here we go.
Video that we have,
Sorry.
that we were able to find, shows him walking his bike on the north side of the street.
No, you're still here.
Now, there has been a lot of discussion.
So bad. No, you're still here, Big Johnson. You are totally here. Like, you haven't missed it. Get your ass in here, girl. No, I've been here the whole night being complete, total, full retard. Yes. This is fun.
From the defense of, well, there's missing video that would have shown him flying up on a hood of a car and all of this, and the bike gets hit. Ladies and gentlemen, he's able to ride that bike for miles afterwards. There's no damage to the bike. You've seen the bike. There's no anything, any evidence to support that there was ever any hit between the car and the bike, anything. Nothing on the bike, no evidence whatsoever. And defense counsel started this trial by telling you how highly suspicious it was that 745 on Casablanca, which would have captured that, is somehow missing. Except, as the evidence showed, that's not true. You heard from Officer Howard, who watched that period. Nothing was there. The Zanya's Pizza, which covers that same area, doesn't happen. So all of a sudden now, we're moving to Gloriosos. Now that's the missing part. And then the defendant takes the stand and says, not even there, further east. Ladies and gentlemen, the police looked for where that incident occurred. They didn't find it. But regardless of it, ladies and gentlemen, all it was a situation in which Mr. Cleereman yelled, possibly swore, and he hurt the defendant's feelings. He wasn't hit, he wasn't injured, there's no damage to the bike, there's no injury to him. And what does the defendant do? I can't let them get away. He gets on his bike. And he follows. He follows them. He goes right past the dynamite where he's supposed to pick up the sushi, doesn't care about this special night anymore. He had one thing on his mind. He was irate, and he wanted to catch up, and he sure did. And ladies and gentlemen, his own words to you tell you that this whole thing about him flying up on a car is a lie. Because he says, were you talking to me? He testified, well, he just wanted to see if they were going to admit to hitting him. But that never comes up. What he says is, I want to know if you were talking to me.
Damn.
And then he punches him. He punches the victim straight in the face. He punches the victim, causes his glasses to fly, causes blood to flow. And he gets on his bike, or stays on his bike, and just continues right around that corner. Now, ladies and gentlemen, yes, the victim put his hand on the car door and opened it and then closed it. And yes, he tells his wife to turn. And yes, they pull around and she stops the car. And he, the defendant, is now up on the sidewalk. And he continues to bike towards those stairs are. And then he stops. And ladies and gentlemen, you saw, yes, the victim starts off with that purposeful walk that several witnesses saw. And then, yes, even though some of them don't remember it, he got into that little bit of a jog. And he gets there and he squares up with the defendant. He's there, ladies and gentlemen. As Jose Perez and Jeff Parr told you, it looked like he was going to confront them. His wife even said to the police at the time, yes, she said he was going to talk to him. She told the police he was going to confront him. Confronting could mean yelling at him, asking him a question. Could be meaning to fight him. Could be doing exactly what Rodtrell Cameron said he was going to do, which was get in that boxer stance. He was going to punch the man, according to Rodtrell Cameron, that had punched him. The defendant threw a punch And then when that person was getting ready to punch back, according to Rodrell Cameron and Jeffrey Parr and Jose Perez and the victim's wife, he pulls a gun, aims it at the victim's head, and pulls the trigger. Victim drops. So cold-blooded. Rodrell Cameron is on 911 saying, "You gotta get here." He's still here. When he talks to the police, dude's gotta go. That was too cold-blooded. Now, ladies and gentlemen, when Jason, the victim, gets there, he has nothing in his hand. Nothing. No weapon. There's no evidence under any circumstances, under any view of anything that has been brought into this case to believe that he had a weapon in his hand. Defense counsel made a very big point over the fact that they were going to have a witness that came in and said that somehow the wife was going through his pockets and they were insinuating as though she was somehow putting the knife in. That also came for what seemed like one of the weirdest sidetracks where the defense was attempting to debate whether or not she even loved her husband. Remember that? A wife that purported to love his husband? Oh my God, she asks, is he right? She's so calm. We're spending all this time when the video that everybody knows about shows her in the back of the squad when the shock begins to fall off and the tears start coming and she goes, "Oh my God, my love. No one will love you like me, my love." She is heartbroken. She held it together as long as she could. Maybe you wouldn't have reacted that way. Maybe defense counsel wouldn't have reacted that way. But to question whether or not a woman who saw her husband's brains blown out of his head in front of her even loves her husband because of some tone is disgusting.
Damn.
And then we get this thing of, yes, she's somehow trying to secret the knife. That makes no sense. First of all, ladies and gentlemen, she told you she went there, she wanted something, she grabbed his wallet. How do we know that? Because the video showed you. She goes to the cops, "I got his wallet." We know what she was doing. She grabbed his wallet. Does it make sense? I don't know what I would do if my wife's brains were blown out in front of me. No one knows. Defense counsel questions that and makes it seem like somehow she's trying to take this knife and put it in his pocket. Ladies and gentlemen, in order for that to be true, Ms. Cleereman, at that moment in time, would have had to realize, I got to take this knife out of his hand. You know what? Instead of throwing it over the wall or putting it in the car or putting it in my purse, I'm going to put it in his pocket. And then, in order for someone to realize, because there's people around, maybe they see me going to his pocket, I'm going to take his wallet so that I've got a ready excuse. That's the amount of thinking that they're expecting Ms. Cleereman to have. And they're forgetting one thing, ladies and gentlemen. When he got punched, Mr. Cleereman puts his hand up, remember? And he says to his wife, "I'm bleeding." That hand, that right hand, has got blood all in the palm. That right hand, that when he touches the car door in order to open and close it, leaves blood on the wall of the door and on the window. So much blood, ladies and gentlemen, that it's literally visible on the car.
Damn.
That bloody hand, in order for defense counsel's point to make any sense, would have had to gone into this pristine pocket by these pants, leaving no blood on the knife or on the pocket or anywhere. Didn't happen.
Damn.
Didn't happen.
See, and I missed this the first go around.
He's fired up.
No, because he's sitting there going, "Oh, and these are things that he never discussed. He never brought up. He never even alluded to it. He just, it would have been one of those little pieces that was tossed out there. This prosecutor is good. Like, whenever I see a prosecutor like this, I'm like, shit. Like, he's doing more than just like that 1-2 punch. He is got them like the whole time. He's just sitting there going, hit me, hit me, hit me, hit me, hit me, hit me. He's the Muhammad Ali of prosecutors. Like, they're just throwing punches and he's just curled up, taking the hits. And right now is his time to shine. And he is laid into them like no other. He's bringing the receipts of every single thing that was brought forward. Their entire case was built on. This right here is the show of a good attorney. Now, whether you like prosecutors or not, this guy is a fucking remarkable attorney. I didn't appreciate it the first time that I watched this. I was like, yeah, this guy's pretty damn good. But watching it the second time, oh my God. Actually, yeah, Tammy Begards, she's saying the same thing. It's like, holy crap, this guy is good. Like, he is just laying into them.
Well, I was captivated by the story. I mean, just follow it, you know?
Yeah. I mean, just every little damn thing. It's awesome.
Mr. Cleereman. According to Rontrell, Cameron gets into a boxing stance, and Rontrell said, I just would have boxed him. But the defendant pulls his firearm, he aims it, he puts one right above his eyes, right above the eyebrow, into the victim's brain, which causes him to drop. A fatal wound. And keep in mind, ladies and gentlemen, what the ME told you about that. Slightly upward. Slightly upward. Front to back, no left to right deviation. It's a straight on shot, just like all 4 witnesses described. Raising his hand with a gun in the hand, because when someone's got a weapon in their hand, you know what it is. You see it. You see that weapon. 4 people saw that gun in his hand. Not because it's down by the side and oh, there's a lot item or they saw the gun because that was the threat and that was the weapon. And Mr. Cleereman takes that bullet into the brain. And what does the defendant do after that, ladies and gentlemen? He runs. He takes off. Instead of taking the direct street there, he ends up taking a bike path in which police would not be able to be driving down. He takes the most obscure way to get to his house where he can't be found or seen by individuals. He gets into the house and he ditches, what does he ditch? The bike. The first thing, the main thing that everyone's saying about who he is the bicyclist. He gets rid of the bike and then he walks and he goes and all we know is he never comes back. The gun that he used, according to him, he just throws it out the window because he, doesn't want someone to shoot him with it. Something that meant that he kept onto it, held onto this murder weapon for weeks through 2 states until all of a sudden he hits the cornfields of Indiana as though some voice comes out and says, if you ditch it, they won't find you. No, ladies and gentlemen, he's getting rid of the gun 2 states away because he's trying to avoid getting caught. That's why he dyes his hair. That's why he goes on the run. That's why he says he's from the Bahamas and tries every last ditch he can to not be held responsible. And when they come down, he plays dumb in the hopes that we won't be able to put it together on him. And then, ladies and gentlemen, it's all, oh, the victim must have had a knife. And when that falls apart because their witness doesn't see anything in the wife's hands and there's no evidence to support he had anything, not one single witness supports that, all of a sudden, at the 11th hour, we go from, yep, I was defending myself to it's an accident. Oh. He tried to get away. He tried to lie. He tried to play dumb. He tried to say the victim was doing something. And now it's just an accident. Now, ladies and gentlemen, those are the facts.
No, he hasn't thrown the knockout punch yet.
The first count you consider, ladies and gentlemen, is first-degree intentional homicide. The counts and elements are fairly simple. First, did he cause the death of the victim? Clearly he did. He shot him in the head. He falls down almost immediately. It's a mortal injury. It's a substantial factor. The defendant, under all circumstances, is the cause of the victim's death. Did he act with intent to kill? He raises his arm, according to 4 people, and shoots the victim in the face. The gunshot, front to back, slightly upward. That's not consistent with anything the defendant testified to, but it is consistent with 4 witnesses and video that show him with his arm and the victim goes down. And intent to kill means this, and this is very important. Practically certain to cause death. That the defendant knew that when he shot the victim, it was practically certain to cause death. He told you he's got weapons training with all his maritime security. He's gone to the range. He's been taught on how to hit what he shoots at. Well, he did. And when you shoot and aim at someone's head, that is practically certain. He knew that. That is intent to kill, ladies and gentlemen. That is intent to kill. And now we get to how self-defense factors in. The third element of intentional homicide is that the defendant did not actually believe that the force was necessary. Did not actually believe. But this only comes into play if you don't believe he provoked the attack. A person who engages in conduct likely to provoke an attack and who provokes an attack is not allowed to use force against the attack. However, as defense counsel will tell you and as law says, if he withdraws and he makes it abundantly clear, he can regain that ability. But keep that in mind about actually believing the force was necessary. He is confronted with a man that he punched in the face. That man has no weapon. He has a gun. He withdraws it and he shoots him in the head. He started a fist fight and then he brought a gun to it. He started a fist fight and he brought a gun to it. That's what happened. That's what he did. He did not actually believe he had to shoot the victim in the face. When the victim said words, he punched him. When the victim gets ready for a fight, he kills him. Every escalation of the violence in this case has come from the defendant. Every time. There is no weapon in the victim's hands. Now, ladies and gentlemen, if, for whatever reason, you believe that the defendant did actually believe the force was necessary and did actually believe that he was acting in self-defense and that there was a threat of unlawful interference, and there's no evidence to support other than his incredible testimony, then, ladies and gentlemen, you go to the next question, which is second-degree intentional. Again, he caused the death, intent to kill, there's no doubt about that. But then we get to do not, whether or not the defendant did not reasonably believe that the force was necessary. And if any one of these three apply, any one of them apply, then the defendant is guilty of second-degree intentional. A reasonable person would not believe he was preventing or terminating unlawful interference. He punches the victim and then shoots him. Keep in mind, this is someone who said he just couldn't let the victim get away. The next one is a reasonable person would not believe he was in danger of imminent death or great bodily harm. When he is looking at the victim, there is no visible weapon. As Retro Cameron told you, he just pulls it and he just shot him in the head. Remember that. On the 911 call and to the police officer, he just shot him in the head. He just shot him in the head. And then he flees. And the last, ladies and gentlemen, is that a reasonable person would not have believed that the amount of force used was necessary. He brought a gun to a fist fight he started. That's not reasonable. If, for whatever reason, you do not believe that there is intent to kill, and you should, because under the law,
guilty
we've
written
talked about
under
it,
there.
it's practically certain to cause death.
Guilty.
His training, he knew it, he's been trained, he knows how to hit what he shoots at, and he did well. Unfortunately, in this case, you get to reckless. Again, cause the death, we know about that, but then we get into criminally reckless conduct. Did he create a risk of death or great bodily harm? He shot him in the face. Was that unreasonable? Did he know it was unreasonable and substantial? At close range, when that individual, the victim, according to Mr. Cameron, according to other people, are just going to confront him, no weapons, no punches, no nothing, he pulls a gun and he shoots him, that is unreasonable. He knows what he's doing. He's been trained. And in this situation, ladies and gentlemen, when you get to reckless homicide, the actual and reasonable belief portions of self-defense apply. It's not like an intentional where if, he actually believes, but it's unreasonable, it's second-degree intentional. In first-degree and second-degree reckless, if you find it to be unreasonable what he did, and you should, then he's guilty of either one of those, depending on how you view the last, and this is important, the last element of reckless conduct, utter disregard for human life. And in this situation, ladies and gentlemen, you are told to consider the defendant's conduct after the incident. You shot a man in the face. That's utter disregard for human life. And the last one, ladies and gentlemen, homicide by negligence, thing that comes out of nowhere. After days of talking about how the defendant was forced out of self-defense to raise the gun and fire it, all of a sudden, after every other thing that has been tried has failed, we now get the gun was pointing down, all of a sudden the guy's spearing him and it goes off. Except the ME and the witnesses show that that's not what happened. He doesn't get slightly upward, front to back, no left to right deviation, except for in the way in which 4 people said it. Pulls the gun, without warning, without anything, and he just shot him in the head. Ladies and gentlemen, in the beginning, defense counsel came up and he said, you see my hand? Do you see everything? Do you see everything about my hand? Well, someone did see all portions of a hand. The defendant saw the victim's hands. There was nothing in them. And he shot him. No weapon. Just a man who's confronting the defendant after the defendant punched him in the face. And for that reason, ladies and gentlemen, he's guilty. Damn.
Okay, hang on one second. Guilty, break. Proceed.
Oof. Just, I mean, is that fire or what?
That was really good.
I
That was
mean,
good.
you know,
Yeah.
the worst part about this is, yo, Lefty, what's up, brother? Yeah. It's, no weasel bullshit taxes, just good, clean case presented. Now we get to B. Iverly Lamar. And in every bit of this, just keep in mind, his whole thing is this is a race-driven issue. That's B. Iverly Lamar is all about race. It has to do with race. Turn on the closed captions. Get that up there for you. Here we go.
I will let the defense do their closing. I would encourage the defense to take the advice the state did and not use the entire hour and a half. It's really not necessary.
Defense used
And
23
1.5
minutes.
hours is an absolute hard
prosecutor
stop.
used 23 minutes.
I'm going to go through lunch. I'm going to tell the jury that I've ordered them lunch. Let's bring them in. All right, jury's coming in. Silence in the gallery. All right, jury back for the jury. We're going to work into lunch. The defense is going to do their closing. The state will have an opportunity to do rebuttal. I've ordered lunch. Lunch will be waiting for you. So we're going to work into lunch, get the closings done,
you okay?
and get the case to 12 of you to deliberate.
Just,
Defense can
I
proceed.
know what B. Iverly Lamar is going to say.
Oh.
Good morning, members of the jury.
He is going to plagiarize Johnny Cochran from O.J. Simpson.
Oh, good.
Yeah.
Robert Kennedy once said, "The glory of justice and the majesty of law are created not just by the Constitution, not by the courts, nor by the officers of the law, nor by the lawyers, but by the men and women who constitute our society, who are the protectors of the law, as they are themselves protected by the law." Members of the jury, it's been over a week now, and as
All
the state
because
has
of
pointed
you.
out, you know, I've seen you very active and engaged in this case. You've been taking notes. And this is a traumatic situation, you know, for both parties that's involved in this case. This case has been filled with emotions on both sides of this case. And, you know, we really just thank you for just, you know, keeping an open mind as we go through the process. Now, the state just talked about, when we talked about the other side of the story. Remember that?
Oh, no.
The defense in this case has established everything that we said we would show you on the other side. The state didn't come up and talk about a wallet. You never heard about a wallet in this case. We told you that the crime scene was contaminated. We told you that seconds afterwards, there was
You heard everything about the wallet. The wallet was discussed ad nauseum.
tampering of evidence in this case. We promised that we would show it to you. That
What?
promise did not come back void. Now we're talking about a wallet all of a sudden. Now, 1.5 years later, there's an explanation for a wallet.
The whole time they've been talking about the wallet. Have you not been paying attention? Oh, wait. You were probably texting one of your hoes. Slaps his attorney and tells him to zip it. Yeah.
Now, the truth of the matter is, no party here knows exactly what took place on September 22nd of 2020 because the state has not satisfied and filled their burden. They haven't proved anything beyond a reasonable doubt. What they've shown is theories. They haven't proved anything beyond a reasonable doubt. They just came up and said, oh, he didn't have a weapon. And then, yeah, okay, it was a weapon in his pocket. And then they talk about, oh, well, it was a folded knife in the right pocket. Oh, no big deal. As if it takes so.
Can I hit him? I just so desperately want to give him a right hook because everything that he's saying is not anything. It was like, wait a second, were you in the same trial that we were?
Right.
Because he, oh, jeez.
So long for a folded knife to become a threat. Here's the knife. It's folded. Could go in a pocket very easily. Here the knife is extended. How long does it take for the night to go from being extended to being folded. Let's find out. Less than a second. Now it's folded. Now, just at the onset here, I want to discuss a couple things with you. You know, you've heard a lot of testimony in this case, and this is a case that, as you can see, just with the coverage of this case, it evokes a lot of passion. You know, this case is, it's a precedent-setting case. You know, this is a rare case that has been presented to you where this time, there's an African-American man who's now using self-defense against a Caucasian man. You don't see that every day. And he's not just anybody. The evidence is so he's not just anybody. He's somebody that's well-respected in this community and has been referred to by many as a prominent immigration lawyer. So, when you're faced with those circumstances, now I want to be the first to tell you, we put Mr. Edgecomb on the stand yesterday. Now, we thought about not putting him up for a couple reasons. Number one is because the state hadn't even proven their burden to begin with. Mr.
No, it was his decision and his decision alone, not yours. It was not his attorney's decision to put him up there. And I am so surprised that he's not being called out on this crap because that's not the way that it works. You have the right. You have the right to not go up on stand. You also have the right to go up on stand. That is a decision that only that defendant has.
No, and I get that part, but I mean, he was terrible.
Yes,
it's terrible.
And he's making it say, well, we didn't have to put him up there, but we did. We put him up there. So you're saying that you forced him up there? That's what it sounds like to me. That's why I'm surprised he's not being called out on it.
Edgecomb insisted, I want to tell my story. We promised you in the opening that we would have him up to tell the story. But Mr. Edgecomb was scared. The same fear that he had after he'd been hunted down by these two individuals. That same fear where he described as being the next Ahmaud Arbery. The same fear he had with turning himself into law enforcement and wondering if he could be taken into custody safely, as he described what he recalled from Sandra Bland. That same fear he exhibited on this stand yesterday. Now the state would say, oh, we can't trust his testimony. Well, let's talk about his testimony. Mr. Edgecomb, we felt it necessary to get out all the bad facts right away. We told you in opening, we're gonna talk about the good, the bad, and the ugly. I told you at the very beginning of the opening statement, there's three things. Mr. Edgecomb was not supposed to have a gun, temporarily, not supposed to be in possession of a firearm at the time. We told you that. He's taking responsibility for that. You heard about Bill jumping charges in this case. He's taking responsibility. We also told you that Mr. Edgecomb did in fact punch Mr. Cleereman. He never disputed it. You heard him come on the stand and take responsibility for it. You heard him come on the stand and say that if I could do this over, yeah, I was upset. Yes, I was infuriated. But if I had another chance to do this, I would simply accept being hit by a vehicle, thrown into another, and being called a nigger. Those were his words on direct examination. What else did he admit on direct examination? See, it's not easy. This is the first time that Mr. Edgecomb ever been set in a witness box before. This is the first time he ever been charged with murder. These are serious charges. Who wouldn't be afraid? Especially in the city of Milwaukee, where you have amongst the largest incarceration rate for African-American men. Of course, he had every right to be afraid. Now, you might say, well, why was his demeanor a little bit different with me than he was with the state? Let's talk about that. Well, first, I will tell you, when I first met Mr. Edgecomb, he was a little bit guarded, even with me.
Objection, Your Honor. As to defense counsel testifying, as
Sustained.
not in front of the jury.
Sustained.
Mr. Edgecomb,
Watch counsel hyperbole.
Mr. Edgecomb has had fears. He going before a government where it's not popular to use that type of force against another race. Mr. Edgecomb, he was afraid of being tripped up. Now with me, he's a little bit more comfortable. He's got a chance to know myself and Attorney Ahmaud over the pendency of this case. It's a little bit different. But he understood that one wrong answer could potentially get him convicted of murder. So we talked about before that he has a diagnosis of attention deficit disorder. We don't want to play that up. He's a very intelligent person, but it's real. And sometimes the effects of that show itself when you're in a very highly stressful situation. Attorney Hubner, great attorney. There's times that both of us have had to exert a certain amount of aggression or a certain amount of assertiveness to get the evidence in this case. The evidence, it doesn't just present itself. Sometimes you have to dig, you have to keep going. And there were times in this case, if you recall, Mr. Edgecomb, was trying to complete a sentence that was not allowed to. He wanted a simple yes or no. Well, every answer does not result in a yes or no answer, but that's the position he was in yesterday. Now, Mr. Edgecomb testified. You heard him say. Now, Mr. Edgecomb had, if you recall on cross-examination, he talked about, the gun went off after he lunged at me. You recall that? He said it a couple times. Mr. Edgecomb believes that he's already made it clear that he shot Mr.
Judge
Cleereman.
is about to go off on him.
He intended to shoot Mr. Cleereman to stop a threat. He did not, however, intend to kill someone. There's a big difference. So every question that discussed homicide or murder or blowing someone's brains out, of course, Mr. Edgecomb was taken back by that and did not want to answer a question in a certain way, so he kept resorting to, my actions were in self-defense. I acted in self-defense. Then he went, and he understood that part of your consideration, members of the jury, is to consider the reasonableness of his actions. We all know he shot Mr. Cleereman. We established that in opening statements. The question for you, though, is the reasonableness of those actions. Part of determining the reasonableness of Mr. Edgecomb's actions is when did he decide to shoot Mr. Cleereman? At what point did he decide to shoot Mr. Cleereman? That's the question. That goes to reasonableness. So Mr. Edgecomb kept reiterating the shot went off at the time that he lunged at me. He's trying to explain to you the reasonableness of what he felt was at the time that he shot. He's not trying to imply that, this was just an accident. He's only trying to discuss the time frame. The shot went off after he lunged at me. Now, Mr. Edgecomb is no lawyer,
It is.
not a doctor. He was on his
He's
way.
trying to get
he had
self-defense
just a
in
few
there.
credits
It's
away
not going to
from
work.
A psychology degree. He had a bright future. But we all articulate ourselves differently. Members of the jury, we're diverse people. The words I might say to describe something might not be the words that you might use. So we don't discredit Mr. Edgecomb based off of wordplay. So when he says, the gunshot goes off after he lunged at me, then he's followed by a very good aggressive question by the state that says, so it was an accident. So you killed him and it was an accident. Well, let's just think about that for a minute. Can you answer that in a yes or no? If he said yes, he just, that's what he ultimately said. Because he doesn't want to say, I intentionally killed Mr. Cleereman. Because remember, he never intentionally tried to kill anyone. He only intentionally tried to stop a threat. Techniques used by a good prosecutor. Please don't hope that it gives Mr. Edgecomb. Go back to your notes. See what Mr. Edgecomb testified to on direct examination. On direct examination, did Mr. Edgecomb not tell you? I went down the stairs, then I went home. I put the gun in. Go to your notes. Did Mr. Edgecomb not tell you when I asked? I was right here, and I asked Mr. Edgecomb, did you give the police your ID at the time you were apprehended in Kentucky? Mr. Edgecomb said what on direct examination? No. On direct examination, I asked him, did you give them a fake name? Did you give the Kentucky Police Department a fake name? What did Mr. Edgecomb say? Yes. I asked on direct, why did you do so? Go to your notes. He explained it. He explained it. Then on direct examination also asked Mr. Edgecomb, did the Milwaukee Police Department detectives come down and when they asked you about something happening in Milwaukee, did you say, what happened in Milwaukee? Mr. Edgecomb said, yes, I said that. Members of the jury, there was a follow-up question to that. Why did you say that? When Mr. Edgecomb was comfortable, he answered the questions. When he's comfortable, he did not hesitate to not answer one question. Fear is real. Attention deficit disorder is a disability. It's real. Anxiety is real. Being charged with murder are real feelings. Every other witness that stepped up here, if they had a bad day on the stand, if we got some information out or they answered the question the way that they might not have wanted to, you know what happens to them? Nothing. They go home. They have dinner, they get up the next day, and that's it. Not when you're the defendant in a murder case. That answer could determine whether you're convicted or not. That's the reality. That's why before he feels like he's getting tricked up on something, he asks the question again. Now, we talked a lot about, the fear. We talked a lot about, what happened on the stand, and these are red herrings. It's a red herring. It's a distraction. Mm-hmm. So now let's talk about the state's burden of proof. Let's discuss it. They have the burden. As the court has appropriately indicated, the defense doesn't have to prove anything. No, everything we came up to talk about, we showed you. In opening, we told you. We've shown that.
No, they came up with receipts. Every single bit of it. And they proved Every single bit of it.
So let's talk about the burden of proof. Now, as you see, the state has that burden. There's a lot of different thoughts that you might have. You know, when you get different parts of evidence, it might lean you one way or not. So it's important to understand that it's only the state that has the burden of proving something beyond a reasonable doubt. It can't be probably, it can't be maybe. So let's go through what the state's witnesses showed us. In fact, we actually like the state's witnesses. In fact, we would have, you know, there's a couple of people that was noticed on the state's list that we thought were great witnesses, and we called them ourselves. A lot of proving reasonable doubt can be established just off the state's witnesses. For example, let's go to the first line. So we discussed reasonable doubt. Again, it's not probably guilty, it's not guilt likely, none of that. All that will result in not guilty. If it's not beyond a reasonable doubt, it's not guilty. And at the end of this,
Knows Edgecomb took his mask off. He's been sitting there the whole time with his mask. At this point, he takes his mask off. He's like, I'm so screwed.
I can't breathe.
this presentation, we're going to ask that you find Mr. Edgecomb guilty on all counts. You know, we started with first degree intentional. You're going to see some lower charges that have been added. We're going to ask that all charges that you find Mr. Edgecomb not guilty. Go to the first slide. Mr. Rotrell Cameron. Now, this is probably one of the most memorable witnesses in this case. He's the only witness.
No. I would say one of the most memorable witnesses in this case was his wife. And how you guys came out and attacked his wife. The victim's wife.
Witness that was brought in with the orange jumpsuit. Mr. Rotrell Cameron, Scover is the highlights of his testimony. He stated that the incident was cold-blooded. He stated that the shooting appeared to be cold-blooded. That's why the state liked his testimony. That's what he was brought in for. Mr. Cameron testified that he was going to pick up his subpoena.
All right, we need a break. Counsel, back to your table. We need a break. Let's take the jury out. I need the gallery cleared right now. Bail's out. Everybody out.
Oh boy.
Quietly and professionally, but out.
Somebody's acting an ass.
Off the record.
Ooh.
Mm-hmm.
Ooh. They really hated the closing.
No. This is during flu and shit like that.
Edgecomb, 12:15. I discussed the situation with the attorneys. Unfortunately, one of the jurors, about half an hour ago, maybe 20 minutes ago, felt a bit lightheaded. She does not feel well. I'm going to make her, and the lawyers are stipulating to this, the alternate. We have 12. I believe we should continue, finish the closings, and let those 12 deliberate. Either side object to that plan?
No.
Great. All right, I'll bring in the 12. The juror, I'm not sure of her number, we'll make a record of that later. It's a younger white female, will be excused as the alternate, given that she's not feeling well. The remaining 12 will come in. All right, jury's coming in. Everyone can remain seated, please. All right, jury's back. Welcome back, everybody. The juror that you saw that was not feeling well, the lawyers and I have agreed she's the alternate. We excused her. There's 12 of you. The 12 of you will deliberate. My bailiffs have checked on her. She's fine. She felt a little lightheaded. She indicated it might have been something she ate, but she feels fine. She's doing better. So we'll continue.
Warned them about that
remember where you were,
pork
pick up
food.
where you left off, but go ahead, counsel.
So members of the jury, we were talking about the state's burden of proof in this case. And just a quick reminder, quick review is that the defense in this case doesn't have a burden, have no burden whatsoever. And we discussed prior to the break that the majority of the reasonable doubt that can be established in this case can actually come directly from the state's own witnesses. So we're going to go through the testimony of the witnesses in this case, and we're going to show it to you. We're going to show you reasonable doubt in that they cannot satisfy this burden of proof. Let's go to the first slide. So the first witness, we discussed Rotrell Cameron. Well, he was one of the state's first witnesses. And what Ratrell Cameron testified to is he described witnessing the shooting occur, and he described it as the words being cold-blooded. Cold-blooded. He used those words. Now, that's why the state liked Mr. Cameron. That's why he's essentially almost their star witness. He's the one witness who could testify outside of Ms. Cleereman, outside of Mr. Edgecomb, who could have witnessed the last 2 incidents that occurred. So we know there was 3 incidents. We know that something started this. Mr. Cameron witnessed the last 2. He described the last final incident as being, it was cold-blooded. Now, what was interesting about Mr. Cameron's testimony is that immediately after he described it as being cold-blooded, he testified that the defendant appeared to be in shock afterwards.
No, he didn't.
Those were his words. He said he appeared to be shocked. I don't know how many cold-blooded, heartless, violent killers are shocked after they shoot somebody intentionally.
It's not what he said.
That was Mr. Cameron's testimony. So what happened? You seen the state, after they worked hard to get this witness here, you seen the state jump up and start trying to impeach their own star witness. You remember? Do you recall? Mr. Huebner was right here. He said, well, you never said anything about him being in shock before. You didn't tell the detective, the officer, that when he was on the phone with you in the patrol car, you didn't say he was shocked. Remember that? Go look at your notes. That's not consistent with being a cold-blooded killer, the way they're trying to make Mr. Edgecomb to be. This is their witness. We didn't call him. Let's look at what else Mr. Cameron told us. He admitted, after the punch, he used a very key word. Mr. Cameron used a very key word when he described it. He was asked, did Mr. Edgecomb, after he punched Mr. Cleereman, did he withdraw from that confrontation? He said, yes. He was asked, was he a threat at that point? He said, no. He admitted that Mr. Edgecomb withdrew once he got on his bike from that confrontation.
Yeah, because he already killed the
You're going to
guy.
see that word withdraw, or withdrawal, again. You're going to see it in the jury instructions. It's going to be under provocation. See, the state wants you to believe that, oh, well, let's see who started it. If you started it, you can't claim self-defense because you're aggressive. Well, they forget about a very important word. It's called withdrawal. See, once you terminate and you provide notice to the party that you've acted aggressively with, you can regain your right to self-defense.
True.
That's the law. You're going to see it in the jury instructions. Mr. Cameron, their star witness, testified to this. What else did we get from Mr. Cameron? He admitted that Theodore appeared afraid when he turned the corner. He almost fell trying to evade him on the bike. Cold-blooded killer, violent, heartless, appearing afraid? Those don't even go together. This is their witness. They caught him on this stand. We asked him. So when he turned the corner, he appeared afraid. I said, when he went from the bike lane and jumped the car, he said, well, he fell. He definitely appeared afraid at that point. When he continued going on the sidewalk, and when he went into this little stairway, he appeared afraid then too. He told you he was trying to go down the stairs. This is their witness. This is their witness. It doesn't matter how loud Mr. Huebner comes up and how passionate he is. These are the facts.
Mr. Huebner hasn't been loud to me.
Now, the state just came up and tried to make a big deal. Now, let's just get this straight. We started and we said this is a very tragic situation. Our heart goes out to the Cleereman family. And this is a situation that escalated and it should not have. At some point, Mr. Edgecomb was responsible for a part of this incident. He punched Mr. Cleereman. He got upset because racial slurs was used based off of his testimony, or whether it was a swear word, whatever the case is, at some point, Mr. Edgecomb got upset. We know that. But at the end of the day, this situation escalated, and we're not trying to go back and forth and do victim blaming. That's not what this is about. As the state tries to indicate, they talked about, well, they said, oh, the wife, Ms. Cleereman, was old. She was not hysterical. She wasn't acting a certain way. We, the defense counsel, never said that. You want to know who said that? Their star witness. Let's go back to Mr. Cameron. Mr. Cameron is who said that. Mr. Cameron described the wife's demeanor as calm, but he was
It was
hysterical.
you guys that said
That's
it
what he
multiple
said.
times.
That's what their witness said. He said, I thought that was a bit unusual because I was hysterical. I was going crazy. I was on the phone with 911, but she seemed to be calm. We didn't put that at issue. Their witness did. So again, let's just put that for the record. Now, as we talk about different things that happen in this case, it is not to, blame anybody, but it's to show that Mr. Edgecomb cannot be proven guilty beyond a reasonable doubt. That's the purpose. We're showing all these things
So what
that
do you
appear
think?
suspicious.
Sunglasses
There's a
are
lot
a
of questions
prop?
that are unanswered in this case. And if the questions are unanswered, they have not fulfilled their burden. This is not about, we
So what do you think? His glasses are a complete prop?
Whose glasses?
This guy.
The guy talking?
Mm-hmm.
I didn't even notice he was wearing any.
Well, he keeps putting them on, he keeps taking them off.
Oh, well, I don't know. I have eyes like that where I need them, but then I can't see anything with them either. So it's like, okay, well.
I think they were just a prop.
It could be.
Yeah.
Never met Ms. Cleereman. I don't know her. Either have you. So we don't know what she would or would not have done. We're not sitting there just trying to kill someone. All we're saying is that the possibility exists. And we don't know. So Mr. Edgecomb should not be convicted of murder because we have a lack of knowledge in that area. That's why we go through all these different aspects of the case that seem a bit suspicious or that warrant more explanation. Or we talk about the failures of law enforcement in this case, and investigators, to not be thorough. And because of the lack of thoroughness, that's why these questions remain. And that's why, ladies and gentlemen of the jury, Mr. Edgecomb should be found not guilty on every single charge. Let's go to the next slide. This is Officer Patrick Tibbetts. Now, the state called Officer Tibbetts. Officer Tibbetts testified that initially...
Yes, Your Honor, state that from Officer Tibbetts. Defense did.
You got your, all right, my apologies. The defense called Officer Tibbetts, my apologies. So with the testimony that was elicited from Officer Tibbetts, he initially stated it was 2 potential witnesses that he believed wanted to give statements. But what did the video show? Remember? Remember the end of the video of his body cam? When he goes and he asks another officer and he says, hey, I see a guy standing over there. I see a guy standing over there. He looks like he might have seen something. Should I talk to him? The first officer says, we were wrapping up whatever he says, it was inaudible. So then he goes to Officer Mahalik, who's coming down. And Officer Mahalik, he says, hey, I see a guy over there. Looks like he has some information that could, in this case, I want to go talk to him. Officer Mahalik says, fuck that, we got enough. Fuck that, we got enough. We got the wife, we got this 911 caller, we got this young gentleman right here, which I believe was Jose Perez. He was in the video, we got enough. That's the evidence in this case. How? You never have enough of anything in a homicide investigation. Mr. Cleereman deserves a full investigation. Guess who else deserves a full investigation? Mr. Edgecomb. He deserves all the facts as well. You don't just jump to theories and rush to judgment. And at any point, this is 43 minutes after the incident occurred on the stairwell. 43 minutes later, you got an officer telling Officer Tibbetts, we got enough. Members of the jury, you proved guilt beyond a reasonable doubt. You didn't do a thorough investigation. Then the evidence showed with Officer Tibbetts that he was instructed to turn his body cam off. He asked, hey, are you live? Are you live? I think that's a fair assertion as to are you recording? Is your body cam recording?
That right there would be trying to put something in there that is not, that is, what, why did you turn your body camera off? Because we were done with our investigation. I'm getting ready to go home. I had to go take a pee. Whatever it might be, it doesn't matter. I turned off my body camera. Maybe we were going to have a discussion about how we were pulling a train on, B. Ivory Lamar's wife.
Dear.
We just didn't want the rest of the world to know about it. Come on.
Think that's a fair deduction? And what Officer Tibbetts does next is he says, should I cut it? He said, yeah.
Yeah,
At that
they're
point,
done.
That's the end of Officer Tibbetts' body cam. We don't know what happened after that.
Don't need to.
This is all reasonable doubt, members of the jury. Next slide.
No, it's not.
So now we come to Detective.
Well, the question is, did he pull the trigger? Did he kill the man? Did he run after the fact?
Right. I think that's been proven.
Yes.
Tyler Kirkbo. Now, Officer Kirkbo, he agreed that any time an item is removed from a crime scene, it is compromised. That's what he told you.
No shit.
He talked about the duty of a first arriving officer to preserve the scene preservation. He talked about that's why you see the yellow tape immediately after a scene, because you don't want to have evidence tampered with. You don't want that crime scene to be compromised. Members of the jury, it's no longer an allegation as to whether an item was removed in this case. I told you in opening, we're gonna prove it. We've done that. Whether the admission was of a wallet or whatever the item was, an item was removed and the crime scene has now been compromised. That's just it. So how do you prove guilt beyond a reasonable doubt? We don't know. Again, we're not making any, listen, we have to put out theories, we don't know. I don't know any of these individuals of these parties. So, Detective Kirkbo said that no citizen.
It doesn't matter anymore with any of what the officer says. By the defendant's own admission, he shot the guy point blank. By his own admission.
Under any circumstance, should remove anything from a crime scene. It should be further investigated.
And they
Detective
did.
Kirkhope also said he can't confirm or deny whether an item was removed or placed at the crime scene. This is the lead detective. So what do? We go back to the burden of proof board. This is the detective. Can't prove anything beyond a reasonable doubt when your lead detective can't confirm or deny whether an item was removed or placed at the crime scene. We don't know. Again, it's not an accusation. We just don't know.
Look at but if you go back to what the questions were that they asked him, was no different than saying, well, did a tree fall in the woods? Well, I can't confirm or deny it because I don't know.
Right.
I wasn't there.
We don't have enough information. Detective Kirkhope also testified that he doesn't know where the first incident happened and he didn't follow up. He also admitted when asked,
You know, the worst part about this is if you look at the pictures they keep showing, it's like court TV shots that somebody was screenshotting while they were in court.
Right.
Like,
Well, how else are they going to get them?
Yeah, because I'm sitting there looking at it, it's just like, these are all shots from court TV or law and whatever their name is, law and crime. That's all they're using is screenshots from there.
The lead detective on the case cannot tell us.
They're like the
where
worst
precisely
pictures, dude. Like,
the first incident occurred when Mr. Edgecomb and the Cleereman had an altercation of some sort involving a vehicle.
So
We don't know. The lead detective does not know. But then we asked the detective, we said, how long would it have taken you to ask Ms. Cleereman to get in the vehicle with you and have her show you precisely this is where it happened?
he just farted.
Sounds reasonable? He admitted it
I
would
think
have
he
only
did.
taken her, mischaracterized, have taken you to ask Ms. Cleereman to get in the vehicle with you and have her show you precisely this is where it happened.
Somebody did.
And you to ask Ms. The lead detective does not know. But then we asked the detective, we said, how long would it have taken you to ask Ms. Cleereman to get in the vehicle with you and have her show you precisely this is where it
Yeah,
happened?
someone farted.
Sounds reasonable? He admitted it would have only taken
Your Honor, mischaracterized the statement that was by Detective Alvarado, not Detective Kirkhope.
That may be the case, but it's closing, so let's move on. Go ahead.
Yeah.
it would take 5 to 10 minutes. 5 to 10 minutes to have confirmed. So we wouldn't be here a year and a half later, members of the jury, still not knowing precisely and exactly where even the first incident occurred. 5 to 10 minutes. They didn't do it on September 22nd of 2020. They didn't do it on September 23rd. And we asked, have you ever done it? In a year and a half that this case has been going on? No. That shows you the quality of the investigation in this case. Mr. Cleereman deserved better. Mr. Edgecomb deserved better. And that is another reason why the state cannot satisfy their burden of proof. Next slide. So members of the jury now, remember we're Detective Alexander LeBlanc.
See, now this right here, another shot from Law and Order or whatever the name of the thing is. Sure, there was a knife found in his pocket, and guaranteed that is not 10 inches in length.
well, maybe when it's open.
Nope.
Hmm.
Next time you get a chance, pull out a tape measure. That right there is about 10 inches. Okay? Just
women can't measure. Come on.
I know they can't. That's why I say get out a tape measure, and you'll realize that knife is probably about that long, which would put it at maybe about 6.5 inches long. Like altogether. That doesn't include the blade. I mean, that's with the blade, that's with it completely
Extended,
expanded.
yeah.
It might be 6 inches altogether. All men measure. Well, I have to because I only want to cut once. Confirmed that police never submitted knife for DNA fingerprinting testing. Why would they have to? It was a guy in the guy's pocket. There wasn't blood all over it. No need to. Confirmed that White Claw can was never tested. Why? Because it was not part of the case. It had nothing to do with it. Confirmed that measurements from Landy were not taken. Yes, there were. Measurements from the Landy were taken, just not where you wanted them to be taken from. Well, did you measure from from 10 miles away to make sure that it was actually 10 miles and 554 feet and 22 inches. And I mean, did you measure it like everywhere, every which way possible? No, because we knew how fucking big it was. Jeez, it's just stupid.
Money was called to the stand. I believe, if I'm not mistaken, that he was the state's first witness, I believe. And he testified that the knife found in Mr. Cleereman's pocket was a folding knife with a serrated blade, perhaps up to 10 inches in length. He confirmed
No.
that police
Well, up to, but
never
not
submitted
quite.
the knife for
Nowhere
DNA
near.
fingerprint testing.
Didn't need to.
Here's the knife. You heard in testimony.
He
that
can't
other items,
measure either.
Like bottles, eyeglasses, those items clearly would make it really hard to exert deadly force toward anybody. But those
He clearly can't measure either, because if he's trying that, I would be surprised if overall length on that knife was 6 inches. Because the blade on it's probably about 2. Maybe 3. If you're lucky. You might have 3. You might have a 6-inch knife there.
those items were tested. Why was the knife not tested?
Didn't need to. There's no blood on it.
He also confirmed that the White Claw can was never tested as well. The White Claw can that was in a back door,
That wasn't relevant to
that
the
can was never
case.
tested either. We don't know whose hands were on these items. And that, ladies and gentlemen of the jury, brings us back to our board. Burden of proof. Can't prove guilt beyond a reasonable doubt. Now, the state came up here and they talked
No.
about, well, his hands were bleeding. And his hands were, came out the door, he got punched, he touched his face or something. So
Yeah, he
that's
wasn't
kinda trying to
expecting
indicate
that.
whether or not, the knife's
Go ahead,
not blood
explain
or
that away.
anything like that. But remember this exhibit, the Fitz 11?
He can't.
This is the pants pocket of Mr. Cleereman. You see specks of something. Could be blood, could be dirt. We don't know. We just don't know. Now, does the state have resources to make that determination so we don't have to guess? Of course they do. This pants pocket could have been submitted to DNA as well. But it wasn't.
But you know what? Those pants are still in evidence. All of his clothes would still be in evidence, as would have the knife been. You just never called it into evidence. You never tested it yourself. You had every opportunity to test it. That knife that you just grabbed up and slung all over the place, you had the opportunity to test that also. Did you find anything on it?
Didn't want to.
And that, members of the jury, brings us back to the board again. Proving guilt beyond a reasonable doubt. We wouldn't have to speculate if the state would have done their job.
They don't have to.
Next slide. Now, it brings us to Miss Evangelina Cleereman. And again, our heart goes out to the Cleereman family. Now, I
No,
wanna,
it doesn't.
Let me just get a couple things clear. Just get a couple things clear. We understand that after, seeing or being involved in such a traumatic experience, one would tend to be distraught.
And that's why you acted like an asshole to her. Oh. Can't measure COs all our life. We were told some of those extra 3 is 6. 3 inches, 6. Yeah, I mean, measurement. Looks like a troll doll and driver's license photo. So those are pretty good.
That's fair. You don't know how you would react in a situation like that, especially involving a loved one. That's fair. Now, the issues that we bring are not to any way, blame, victim blame,
Yeah,
or
there
anything like
is.
that, as we
Yeah, it is.
just discussed. But when there's conduct which is somewhat suspect or it brings or begs a question, we have to present it. We have to bring it to your attention so that you, the trier of fact, can determine whether something has been proved beyond a reasonable doubt. So,
But they also tried to, and it was really weird whenever this first happened. There was a lot of people that came out accusing her of hiring a hitman to take out her husband.
Oh,
That was the rumor that was going around because they knew that it was a black gentleman. And the narrative wasn't fitting around them having having a white wife, because they wanted to make it all race based, and his wife wasn't white. It wasn't like
Right.
this cute little, dotting old white couples, that went to, the KKK rallies on the weekends, and waved around their Trump flags and their stars and bars. No, this was just an immigration attorney and his wife of color. Oh, so how do we carry this narrative? We say, well, she hired a hitman to do this. That was part of the rumor that was going around at the time, because nobody knew.
One thing I can say is that, there's several things in this testimony that, we have questions about, some of which, like I said, could be reasonable
Like
under
what?
the circumstances. But the state has not proven beyond a reasonable doubt. Her testimony
has.
is simply not reliable.
Yeah, it is.
It's just not, and we don't know through why. So it doesn't mean that, she's a bad person. It doesn't mean that, there's any type of issue. But it just means that simply because of those circumstances, her testimony is not reliable. Let's start. The first thing that she recalls saying, she said her husband said, "What the heck?" That was her recollection. She said, "What the heck?" Ms. Cleereman went and did media interviews, and she told those journalists that Mr. Cleereman said, "What the heck?" There. Now, on the body cam, we showed you in evidence Ms. Cleereman clearly saying, "What the fuck?" Now, the issue is, it just goes to the reliability. This could indicate a tendency to water down the situation.
Shouldn't
that was
have
a little
gone
more
there.
severe than
Shouldn't
what
have gone
actually
there
was.
with this.
There could have been some things said that was beyond what the fuck, as Mr. Edgecomb claims in this case. But that tendency, we don't know. Ms. Cleereman also says she saw...
You don't know, so don't bring it up.
She also says she doesn't recall her husband opening a door after being punched by Mr. Edgecomb.
Yeah.
Now, again, when you have a traumatic situation, I'm sure this, when Mr. Edgecomb came up, and I'm sure the stage is going to come up, he came up, he violently punched him in the face, blah, blah, blah. We know that. But we have to now assess her recollection now, and the credibility, because you members of the jury have to determine the veracity and the weight that you're going to credit her testimony. So what she testified to is that she doesn't recall the door opening when Mr. Cleereman looking to exit, likely to proceed after Mr. Edgecomb at that point. Now,
I'm done. I can't do any more of his voice today. I just can't. He is killing me just with his stupidity. It's like, oh my freaking God. Oh,
What a mess.
yeah. Yeah, I mean, he's been just been so obnoxious and annoying. Like, what is up with this guy? That he's got this issue that he just can't let go. Yeah, the longer he speaks, the worse it's getting for him. And I mean, he's made some good points, but they're so far and few in between, he doesn't know how to focus. I mean, as an attorney, you have a story, you tell the story, you make the story. But if you start throwing out things that are not relevant to the case of because of his color, because his feelings got hurt, like this is a sign of a man that has no concept of proving a case. He's wanted to say it was a hate crime that this guy was committed against him, and that gave him justification for killing somebody. The rest of the world doesn't believe that.
Right.
There's very few people that believe that, and those are usually very ignorant people until they're confronted with facts, and then they have a hard time dealing with those facts and usually shut down. And that's why you won't see them on a jury, because whenever you have an attorney asking them questions, they get their shit disqualified really quick. Because they're not able to look objectively at what's going. They don't have any cognitive thought, and I think that's the problem that B. Ivory is not used to, because he's never had to try something like this in front of a court. It's
Right.
always a race-based issue, Like everything right out of the gate, race, because he's a black man scared of the white world and colonizers and all that kind of crap. And he just misses. It's like a swing and a miss. You're speaking to the wrong kind of jury because they're smarter than that. At least you would hope they are. Ladies and
And they
gentlemen,
probably are.
at this point in time, I'm going to probably kick you guys over to, I don't know. Let's see who's going tonight. What kind of folks do we have that are up and running? We've got the experts going on. He is live right now. Oh, you know what we're doing? We are sending you guys over to the expert, and I want you to give him a hard damn time. That's what we're going to do with you. You folks have a wonderful evening. And Rosalind, thank you so much for hanging out. You've been a pleasure.
Absolutely.
That and Bad Duck gets all excited, and
And then he runs away.
I can't help it. I'll see you, chat. I will see you guys in the morning.
Bye,
Peace,
guys.
y'all.